in a matter, my lord. This is for hearing a matrimonial first appeal. Paper books are complete, my lord. Will kindly, my lord. It is appearing in the heading other hearing too, my lord. Will kindly keep it in the matrimonial heading hearing and fix it on a particular date, my lord.
Hearing not now. Applications.
My lord, application
Applications.
and FMF.
Give the applications.
But make that at least be rectified and be put in the matrimonial.
Couple of weeks.
But only one urgency. And only one urgency is that this is an application connected to a custody matter. But there was a direction by the division bench that the father will have a visitation right and the child will stay for a whole day.
Yes.
There is a strict violation of the honorable court's order, I am only seeking if this matter can be anyway, it can be
Give
placed
the-
in urgently,
Give the applications, they will come. As
Well, it
per
is-
their
it is-
procedure term. Yes.
It
Give the application.
Matter is pending, man.
Your Lordship,
Just a minute. All
Lordship, may I be
applications. Yes.
permitted to
Give the
mention-
41 order 41
Order
admission
41.
matters.
My lord, order
Upgradation, please no.
41 rule level.
Sir, everybody is waiting. Please wait. Yes.
Your Lordship, Order 41.
Give the order 41 admission matter.
Kindly fixes a date. It's very urgent, Your Lordship.
Please give the slip. It will come as per seriatim. Yes, application. So you have filed an application. Then give the application.
My lord, for paper book, my lord.
For extension of the interim order, then it can be listed at the top for orders.
My lord, one hearing matter, my lord, for preparation of paper book, my lord.
Sorry, sir. You please, hearing matters, wait for a couple of weeks. And it is appearing under which heading?
It's supposed to appear under matrimonial.
Just give the detail. They will rectify. Just rectify the heading.
Whenever your lordship takes up the matrimonial, I'm grateful.
Order number 1.
Lord, item number 1, my lord, the appellant was moving in person before your lordship, my lord, on the last occasion also. There has been a difficulty, my lord. I'll just indicate. My lord, the erstwhile advocate, my lord, Mr. Shubhajit Bosch, my lord, he, my lord, gave a no objection, my lord, to the appellant hearing. Subsequently, my lord, the appellant lost it. My lord prayed for another no objection, that was not given. That is the reason, my lord, the no objection Wakalatnama cannot be filed, my lord. My lord, his only request is, my lord, so that the appeal may be withdrawn. He has, my lord, written a letter, my lord, accordingly. The letter to the erstwhile advocate is there. Only, my lord, because of the procedural difficulty, my lord, he has, my lord, requested me to, my lord, to move before your lordship, my lord.
There is a procedure for withdrawing of a Kalatnama.
Procedure, my lord, yes, my lord, I went to the, my lord, the register, my lord. Register said, my lord, no objection should be brought. My lord, my lord, made an affidavit to the effect, my lord, that no objection has been lost. Further, no objection is not being, my lord, given. So, my lord, therefore, my lord, kindly, my lord, accepts my wakalatnama. My lord, the registrar, my lord, said, my lord, said to him, my lord, to move before your
So would refuse to give a second no objection.
second wakalatnama. My lord, I have a, my lord, a letter accordingly, my lord. Yes. Yes. My lord, kindly, my lord, sees the letter, my lord. Eta judge সাহেবকে দিন একটু। Yes. This is, my lord, the original. Here's, my lord, the track report. পুরোটাই দিন জজ সাহেবকে। ভট্টাচার্য সাহেবকে দিন।
The learned advocate.
Yes. Requesting him, my lord, to give a second wakalatnama.
Whether this has been received by him.
Yes. My lord, the track report is there.
Can it be accepted like that without an affidavit?
My lord, without an affidavit. If your lordship, my lord, so directs me, I'll instruct him to file an affidavit.
Better, that is the procedure that is being followed here. Therefore,
My lord, certainly, I'll do
we
it.
are asking
My lord, I made an affidavit, my lord, to be submitted to the register so that, my lord, the wakalatnama is accepted without the no objection. That was, my lord, the registrar said, my lord, he cannot do it, my lord, unless it falls from your lordship.
So now you are before the court.
before the court, my lord.
Relying upon a communication which you say you have already sent to the council.
Yes,
This fact should be on a,
certainly, my lord.
then we can take cognizance.
Certainly.
Do whatever we want. So can you file tomorrow?
Yes, yes.
So not today.
Not today.
Just take this back, not today.
Lordship, would your lordship be pleased to direct me in a one-line order, my lord? So that, my lord, the affidavit be accepted before the
The
department.
problem is who is appearing today. That
That is the
biggest
difficulty, my lord. He is here, my lord.
Can he shoot over the learned advocate's head and appear directly when he is represented through an advocate?
Yes, that is the difficulty. But,
Is
my
it-
lord, the difficulty would be, my lord,
Which
Other-
is the procedure for withdrawing wakalatnama under your rules?
no objection is the only procedure. My lord,
It is a procedure. I remember in one case, one gentleman had withdrawn his wakalatnama by filing an application. That was under some particular provision which we had relied upon. This bench then was being presided by His Lordship Justice London. So can you point out which rule is there in the appellate side?
my lord, my lord, take instruction, my lord.
If you go through that, you may be in a position to
To file my application, my lord.
rectify things.
My lord. Lordship, then, my lord, adjourns it for a couple of days, my lord. In the meantime, my lord, if the my lord, I'll file the necessary application
Will come on Monday.
next Monday. Grateful.
Otherwise, who do we consider the council today? That will be a difficulty.
My lord, well, that is a
And when the party is represented by an advocate, can he be permitted to make submissions directly?
that is the difficulty, my lord. Grateful.
Oh.
Come on Monday.
Number 2.
Lordship, I'm appearing on behalf of the appellant and I'm praying for 2 days adjournment.
I appear for the respondent.
These are adjourned matters. Why again adjourned?
Lordship,
Matter has been appearing for quite some time, and all the
You-
time they have prayed for accommodation.
on last occasion, you were not there. A 45 minutes hearing was conducted, but you were not there. That's why this day was fixed. Our senior, we have engaged our senior. Our senior is not available today. That's why we are praying for this adjournment.
Next week.
Next week.
Grateful.
As
Lordship.
paid by council for the appellant next week. List in the next week.
Number 3. Order number 3. Order number 3. 3. Appearance time. Appearance. Why they keep writing?
Lordship, answer the appellant.
I'm here for the OP number 1 and 2.
Lordship, this was transfer brief. Lordship, I have received the brief.
I have filed my opposition. She used to file the reply, but I find that the advocates have changed. She was not appearing on the last occasion. Mr. Kumaresh Dalal and Mr. Dilip, they were appearing. Section 5 application. The appeal was finally decreed in 2014, against which in 23 they have come up with an appeal, second appeal. And in the execution proceedings, they were cross-examining the witnesses. She's a junior member that execution proceedings are going on.
Yeah.
How much time your lordship has granted? Much obliged.
Mike bench. Appeal bench. Na? Five. Yes, my lord, I beg to appear on behalf of the appellant, my lord. Here on 26 June, my lord, there was an order passed by your lordships to file the affidavit in opposition to the state.
Opposition, but unfortunately, I could not serve the opposition upon my learned friend, Lordship. Can you take it up next week, Lordship? I am filing the opposition today.
Yes, ma'am.
I have served the opposition.
I am grateful.
Grateful.
Like copy. What are they? Wait, sorry. Sorry. Order number 6.
May it please your lordship. My lord, this is that appeal with regard to petroleum. My lord, I shall tell your lordship. My lord, first your lordship will please to admit the appeal. This is an appeal from a decree for eviction. There is no question of, my lord, delay. Therefore, this is first application is an application for admission of the appeal. And second application is the application for stay. Well, I am praying for if before your lordship, my lord, kindly admit the appeal so that we can proceed with the hearing of the applications which are connected with the appeal. My lord? Yes, sir.
Of admission,
But there is an application for admission. Well, that has to
it
be.
doesn't require an order for admission.
No, no,
It is-
because under section 96, I am entitled to prefer the appeal as a matter of right.
It is to, under the rules, it is to be admitted by the registrar.
My lord, it is before your lordship, my lord, that
Oh, it must.
because
be.
unless the appeal is admitted, I cannot move in any matter.
It is,
Either they here or there, my lord, wherever it is. Before your lordship, kindly admit the appeal.
no, we are just seeking your assistance because the rules say that admission order is not required on the judicial side.
My
it
lord,
is in court.
well, generally it is not. In
Yes.
fact, my lord, we generally make the application for admission of the appeal when there is a delay. For condonation of delay and admission of the appeal.
Then it is understood because unless
Yes,
the delay
quite
is
right.
condoned,
But
it
my lord,
cannot
there
be.
is no delay in this case.
So therefore, that is just a formality that's not required.
It's a formality, but my lord, this formality has to be either, my lord, done before your lordship or before the.
Otherwise, what is the procedure on filing of a first appeal? What is to be done by the registrar? If I remember correctly, if what I saw
Well, so far as
is
I
to
know,
be
my lord,
admitted and orders passed for notice on the.
yes, so far as I know, my lord, it is filed in the department. My lord, the department, if there is, my lord, delay, any delay, then my lord, an application will, my lord, the department will not accept it. So
Correct.
we'll have to come before your lordship along with an application for
Yes.
condonation.
Yeah.
So this is subject to correction. My lord, my Mr. Kaur, my lord, knows a lot of things about this.
There is never any admission of appeal.
Yeah.
Normally, Lord, when the appeal is in proper form, Lord, and there is no defect in the appeal, Lord, the appeal itself is placed before the court. And Lord, the stay petition is considered. by
Correct.
the-
Right, right.
That is what we have gathered from the rules also.
That
No
is-
order is
that is
required
what it
for
is.
admission.
That is exactly what I'm saying. That is what it is.
Hmm.
But
So
now,
we can proceed to consider the application.
my lord, unless the appeal is admitted either by your lordship or by the department, my lord, I am not in a
So
position
if
to.
it is done
because
by
I
the
have got-
department, then what is the procedure? How does the court come?
It comes before your lordship at the requisition of the party who is preferring the appeal for hearing of the application.
Which is the provision? Let us see.
My lord,
Speaking for myself, I would have to see it,
yes, quite right.
please.
Then, my lord,
Huh? Yes, you may.
if there is a note from the department, then my lord, this is.
আমার কিছু করার নেই, ওটা ভুল করে দিয়েছে।
It appears ওদের কিছু করার
Mr. Ka, we also need seeking your assistance. What this is just a matter of procedure. Therefore, we want to see what is the rule position
Lord,
and whether such orders are required to be passed, are being passed.
it is never.
As far as I have seen in the last 5-6 months.
It is never passed.
Yes,
There is no formal order of admission.
correct. That is what we have seen.
Only thing that is done is if there is a delay, then your lordship condones. the
Then of
delay
course,
and-
the appeal will not be considered unless the delay is condoned. Therefore, we condone the delay and direct that formal registration of appeal.
Formal registration. And here, my lord, the appeal, if there is no defect, it is formally registered and then placed before your lordship.
Yes.
Well, I am told this. What happened was this: when the appeal was filed, my lord, with deficit court fees, so the proper court fees was not paid. So, my lord, there was an endorsement by the department that you put in the deficit court fees, which was done. But, my lord, this after that,
It
after
was not placed in the department.
then, my lord, it has come before your lordship.
So it should go back and Lord, the report should be called for.
Then it has to go through the report again whether the court fee has.
Yes, my lord, this is there. It is there. Court fees has been paid.
So both fees have been paid, but it has to go through the department.
Department থেকে পাঠিয়ে দিয়েছে।
So
It has been sent by the department before your lordship.
it has been filed in court or it was filed before.
Online. Now we let e-payment now.
There is no note regarding sufficient court fee having been filed.
That receipt is there.
Correct. So it has not gone to the department. So it has to go to the department. The court fee has been filed.
Yes.
So then you won't be pressing your application today.
I will press my application unless it is admitted, my lord. I cannot move the application. That is the problem. My lord, I will have to have the appeal admitted before, my lord, I can move my application.
Take down the learned counsel for the appellant submits that the deficit court fee has been deposited by its serial number 1 on 27/6/2024. Stop. Since the defect as regards court fee, deficit court fee has already been removed, the office may proceed for formal registration of the appeal and consequential orders in accordance with the rules. Yes.
Lordship.
Yes.
Now, my lord, my application for stay is there. My lord, we have আমাদের এই application করা হয়েছে। My lord, we have in this appeal, one application has been made for the stay of the decree. A decree was passed on the 22nd December 2023. My lord, that decree was put into execution, and an execution order was passed, my lord, on 13th March 2024, my lord, they filed a titled execution case. And my lord, on 14th June 2024, my lord, an order was passed by the learned trial judge, my lord, executing the decree, the executing court, for, my lord, execution by taking possession through bailiff. And my lord, in pursuance of that, on 24th June of this year, my lord, the bailiff has gone and taken possession of the property. And my lord, our grievance is this: the bailiff, when generally what happens is that a notice is given to the party that remove your things, we are going to take possession. That was not done. And our grievance is this, that the bailiff went there with a number of, my lord, I am told 200, my lord, antisocial elements, the Gunda element, they went there. And my lord, if I may show to your lordship the photograph, this is how. The copy though. Now,
What is being shown to your lordship is not even pleaded in the stay petition.
No, we are not on that at the moment. We are on this, that just since we have directed the office to proceed with registration of the appeal, should we proceed with the CAN application or it has to come back from the department?
my lord, this is a formality. If your lordship thinks that I should go back and come back again, I don't mind, my lord. But
Just
then
we are
again,
thinking whether if the procedure requires it, we should avoid it for any particular reason or it should go through that. That is the procedure, then it is better.
This is purely procedural thing.
Yes.
And my lord, particularly when there is the defect, if, my lord,
There
whatever
is
is
one
the
more
defect has
defect.
been-
We have to pass an order on that also.
That defect will not, it is a wrong noting.
No,
by
but
the
it is
statute.
pointed out, it will come back with it. Therefore, we are asking you. Unless we pass an order with reference to that other defect on.
Have nothing to do with that. That is a wrong recording by the stamp reporter. Because the name is there with the decree, we have compared it with the memorandum. Name is there.
Yes, you were pointing out on the last occasion, your instructing counsel was pointing out.
Lordship.
What was that?
Lord, they say, Lord, some names have been additionally added. They were very much in the decree. Original, Lord, the kindly see memorandum of agreement.
তোমরা কে কাকে অ্যাড করেছো বলছে এসব রয়েছে।
The other, what was the other defect?
Well, what I have been able to understand from my learned junior, well, that the department was of the view that certain persons had been added in the appeal who are not in the trial court, in the suit. But in fact, my lord, that was a mistake on their part, because, my lord, the decree itself shows, my lord, if your lordship looks into the stay application, memorandum appeal, look at the memorandum appeal, and all these persons who had been defended, they are there, my lord, in the appeal. There is no additional persons have been added. So that was pointed out to the department, whereupon, my lord, department pointed out that there is some deficit in the court fees. That was paid, and whatever defect was there has been cured. So, my lord, the matter has come before your lordship.
So respond number 1 in the present appeal.
Yes.
But no application.
All these are parties in the trial.
Respond number 1 is not a party.
Yes, yes. Respond number 1 is
What is
party
the
of-
party position in the
Uma Gupta.
in the suit? What is the party position?
There's a plaintiff. He is the plaintiff number 1, Uma
And
Gupta.
there is another one also. Plaintiff number 5.
Plaintiff number 5. Yes.
Yes, she's also there.
Plaintiff number 5 of the certified copy of the impugned decree does find place in the cause title of the instant memo of appeal in spite of being deceased. In spite of being deceased, she has been or he has been impleaded. Who is plaintiff number 5?
Oh, Radhika Agarwal expired on her own, cannot continue in the subsequent. So this has to be deleted. Leaving a delete.
That has to be deleted. So only that is a defect.
That is the defect.
Insofar as the other defects pointed out,
That is the only.
it is by the department, the learned counsel, apprises of the fact that respondent number 1 is very much a party to the suit. We therefore ignore the defect insofar as respondent number 1 is concerned. But insofar as the defect regarding plaintiff number 5, the learned counsel is permitted to take steps during course of the day. You take steps during course of the day for respondent
Your
number 5.
lordship will please to give my advocate on record leave to correct.
Yes, we have said during course of the day to
Yeah, lordship.
take steps.
Lordship.
Let the matter come back on Friday.
On Friday.
Meantime, the office will. Yes, why you are?
My lord, we have filed a supplementary affidavit giving, my lord, subsequent facts with regard to the taking of possession of the property. My lord, kindly
It
give
has
me.
been served.
Yes, sir, it has been.
Not-
My lord, yes, it will be served, my lord, after your lordship grant me leave. Without your lordship leave, I can't serve.
Kindly do not grant the leave today. Let us not come back on
Why?
Friday.
Supplementary affidavit, I am entitled to file at any time.
It can be done by supplementary affidavit or Malay.
I am making-
We have to apply under order 41.
Well, I have already also made an application. There is no
It's
question.
additional evidence.
No additional evidence at all. What I shall tell you, lordship, what has happened. My lord, I have given the subsequent facts, my lord, which have for the purpose of stay application only. What I am submitting, my lord, let me clarify the position. The suit has been filed, eviction decree has been passed. The decree is sought to be executed. Possession, physical possession has been taken forcibly. Be that as it may, not only, my lord, it has been possession has been taken. This particular petrol station has been, my lord, enclosed with the high wall, which has been constructed by the decree holder in the meantime. The result is this.
Mr. Mitra, you were not here on the last occasion.
Yeah.
They were represented, they said we have no objection insofar as taking out of the petroleum product.
Yes, quite right.
For that, if we have to allow them ingress, egress, we will do it.
That is the application I have made.
So therefore, that may not be required in view of the stand already expressed in
No,
the
but
court
then again,
proceedings.
that has to be brought on record.
Let us
I
see.
have made a formal application, giving the photographs, showing as to what has happened. But this your lordship we will please to consider.
No, no. So therefore, we are saying, let it come back. On that day, we'll consider.
Yes, but my lord, I have already taken out an application. I'm going to serve it upon my learned friend because we cannot go on waiting because this 55,000 liters of petrol and my lord, diesel are lying underneath.
Yes.
And my lord, this particular area is surrounded by hospitals and
So that is their concern also. They also
Yes,
want it to be removed.
I'm
So
sure, my lord,
on the last occasion, therefore, we had asked what is the best way to do it.
my lord, in fact, my lord, I sought the help of assistance of my learned friend
Yes.
for the purpose of helping me as to try and find a solution to the problem.
Yes.
me, sir. Oidike.
No. I have
You are the best person.
no. It is not Oidike. Not Oidike. Eidike.
What is it?
Well, my learned friend says
My learned friend.
my learned friend said that side.
Yeah.
I said, no, I would much rather have the assistance of my learned friend.
No, but you are the best person. You are the corporation. You know of all the rules. You have come across such situations throughout the country.
Yes.
Therefore, we had asked
That is why the
that you
application.
please seek instruction from your whoever
I
is
have,
the
my
competent
lord,
authority.
when I move the application, I shall show to
So
you.
let it come back
This is
on the
my lord-
next date.
yes,
We'll consider
Very
that.
well. On Friday, I come back and I shall tell you, I shall try and give your lordship some kind of a solution because this has to be done. Whether, even if I don't succeed in the appeal,
No, whatever it happens, the petroleum product lying there has to be dealt with in the larger interest of the
this is the last
locality.
thing. Correct.
And he will also never be able to utilize the property unless it is
Absolutely.
removed.
So long as.
So therefore, we could appreciate on the last date that the parties were ad idem, at least on this, that has to be removed. The concern of the court is it involves too many formalities under various statutes. Act,
Your
rules,
lordship knows,
control
my lord,
orders,
the formality.
act, rule, control orders and explosives.
Yes, right.
So
right.
therefore, we said either you come with a solution how it can be done complying with this.
I shall come back. I shall come
On
back.
the next day, we'll consider that. Let it come after the formal order. On Friday, if parties are agreed. You're not, your matter is not on board today. It's already been adjourned. For 2 weeks, you had sought 2 weeks. It has been adjourned for 2 weeks. No, I think if I remember correctly, it was perhaps adjourned for 2 weeks. So it will come. It will come. Correct.
He has two
We
hurdles.
we have to hear you, but only when the matter is on board. Then
He has two hurdles. First is, Lord, he has to get through with his application for leave to appeal. He has to establish that he has a right, Lord, to file that. And Lord, secondly, his appeal is delayed by a number of days.
No, he has already sought an adjournment. His appeal will be considered when it is listed, not today.
Much obliged.
If Friday is okay, then it can come on Friday.
Lordship.
Right.
Much obliged.
Number 7. 7.
To appear on behalf of the appellants.
Yes. Yes. Which application?
Restoration application.
You have served.
Served. I filed the affidavit of service.
There is an application for condonation also.
Recalling the order dated 22nd of January 2020, passed by the then division bench, presided over by Justice Sambuddha Chakraborty and Honorable Justice
You
Hiranbhai
have filed
Bhatti.
the application in 23.
23.
So after 3 years. Why there is no- What is the system? You are supposed to file an application for condonation. Can you file an application for recall after 3 years?
This matter was out of list then, but suddenly it appeared, and due to misposting of the diary,
That we have seen, we are asking, you have filed the application 3 years after it was dismissed, almost 3 years.
but I have to take instructions from my
It is your, see your paragraph 2 and 3 of the application itself.
Oh, yeah, it was not filed.
You have to,
If your lordship's permit, we'll file it.
but what is the number of days of delay? Because in between the corona pandemic has come, you will be entitled to some benefit for that period.
But we have filed this application on 1st of December 2023.
Why there is no report by this department? Why there is no report by the department regarding delay? There is a CAN application filed for restoration, comma, the full stop. Prima facie, from the averments made in the application itself, it is obvious that the application has been filed in August 2023, December 2023, whereas the matter had stood dismissed for default on 22/1/2020 itself. So we, however, find that there is no report of the department with respect to delay, nor there is an application filed for condonation of delay, stating therein the number of delays, the days of delay as per the appellant. Full stop. The matter is therefore sent down to the application being CAN number so and so be tagged with the records and application, and the application and file be sent down to the department for proceeding in accordance with law.
Obliged, my lord.
Then for condonation of delay, it will come here or it will go to for restoration it will come. Yes, next.
Item number 8. Evening services. Item number 8. My lord, in this matter, my lord, I am appearing for the plaintiff appellant. There is an application, my lord, for though it is couched in stay, but it cannot be stay, my lord. The final degree cannot be stayed, my lord, for injunction. So let me serve a copy upon the opposite the first time, and there is a direction for addition of party by the learned register while added to appear in lodging. So leave may be granted to text to rectify the only the parties to be added, my lord. Other heirs are already on record. One heirs who have been left out, we add.
So unless all the parties are record, how can you serve the copy?
No, the original dependent died. 2 sons and daughters are already on record. Some are missed. My lord, for the wife has been missed out. The respondent number 7 for the code below. In the memo of appeal, my lord, that leave was granted by the register. For the, if your lordship kindly takes up the order dated 29/4/2022.
So this defect has to be removed first.
Yes, leave may be granted to I'll serve the copies of this application upon the opposite parties.
Only after the defect is removed, then you can be allowed to serve the copy.
Beg your pardon, my lord.
Unless the party is on record and the defect is removed, how can you serve a copy?
No, here and now, my lord, I can amend the cost only.
The learned the counsel advocate on record.
Yes.
Advocate on record is permitted to take steps for bringing on record the defendant number 1 of the suit in the present memo of appeal, comma, here and now, stop. Let notice of the application be served upon the respondents and affidavit of service filed within a week.
The matter to appear
Within a week.
within a week.
File it within a week. Matter made returnable after 2 weeks.
Careful, dear lordship. The correction to be
Tell me the moment.
second capitation Item number 9.
My lord, I appear for the appellant, my lord. My lord, last Friday this matter was taken up when my lord, my learned friend on the other side, my lord, they wanted, my lord, service of copies of the applications. My lord, in connection with the appeal, my lord, there are pending 3 applications as of now. Can 2, Can 3 and Can 4, which we have served. My lord, essentially, my lord, Can 4 has to be taken up first because, my lord, Can 4 is really, my lord, to record the change of name of the, my lord, appellant, which has happened, my lord, in the meantime, my lord. And Can 3 and Can 2, my lord, for order 41, rule 27 application, and there is one other application praying for an
Can 4 is for change of name.
for change of name.
And Can 2?
Can 2 is under order 41, rule 27, which, my lord, possibly
That has to be considered with the main appeal.
with the main appeal, if they
Yes.
wish to, my lord, use an affidavit, they can use in the meantime.
The other 2 Can applications.
And other Can 3 application is, my lord, we are praying for an order for production of one of the documents which is in their custody. My lord, that also, my lord, it is appearing for the first time. Affidavits have not been exchanged. This is the position so far as the applications are concerned. my
There are
lord.
only 3 Cans.
3 Cans. And, my lord, Can 1 was the original stay application where there was already a direction for affidavit issued. And that is, my lord, pleadings are complete, my lord, otherwise.
So regarding Can 4, there is
My lord, I'm appearing for the respondent, my lord. There is a problem arose, my lord. We were appearing for the respondent initially, my lord. There is no instruction from the client that they have changed their advocate. Suddenly today morning, my lord, I heard that they want to change their advocate, my lord. So, my lord, kindly give me 1 week adjournment. I have to take proper instruction from the client, my lord. How can both the advocates appear at the same
who
time?
is the other set?
Other side,
No, no, who is the other set of counsels as per?
Other set of Apollo.
My lord, I'm appearing for respondent number 1. I've got the wakalatnama from them. We are yet to receive the NOC from the previous.
That has been not given to us by the client, my lord. So I'm saying 1 week.
There it appears that there is some, my lord, dispute between the erstwhile advocate and the present advocate, but wakalatnama has been given to the present advocate. And my lord, can 4 is really an innocuous prayer, my lord. No party would suffer, my lord, if lordship allows can 4, because I have to then cause an amendment to the cause papers.
Unless the defendant, respondent is represented, how will we proceed?
My lord, since my lord, one of them
That is
have
the
the,
formal, so therefore we ask them that they.
my lord, last day lordship wanted us to serve them again, my lord. We have served
Who have you served? That is the issue.
the new advocate who has wakalatnama as well as the old advocate.
How can you object when she is appearing with a fresh wakalatnama?
We don't know anything, my lord.
It
from
is
this.
without no objection.
Yes,
Yes, my lord. We haven't received the NOC yet.
and we have not
Client
been
also
informed.
didn't inform us about this.
Client ke direct- And difficulty is they are proceeding with the execution in the meantime, my lord.
It has been lying here for such a long time. We don't know whether
Yes,
there is any urgency or not. But the point is, this is very unfortunate circumstance. What do you expect the court to do? You decide amongst yourself which counsel is going to represent.
Instruction, we have to talk to the
Instruction.
client. We did not know, my lord, so that.
Last confusion happened Friday also.
This confusion was there last Friday also, my lord.
No, it was not. Last Friday only she was
We have
at.
no copies of the CAN applications.
She was saying she has not been sent.
Client hasn't informed the previous advocate about the NOC.
My lord, may I do this, my lord?
Please don't bring this to court. You sort it out immediately.
I thought we will talk to the client.
My lord, may I do this, my lord? As abundant caution, may I also serve the client once again directly, my lord? Their client, my lord. Once again, my lord, directly. So that, my lord, next day, my lord, when we come, my lord, at least service, there won't be any issue with regard to service.
All four.
Yes, my lord, can 1 they had appeared, my lord. So far as 2, 3 and 4, though we have served the new advocate.
You request for fresh service, then you decide whether you want to serve all or you want to serve 3. You are seeing what the situation is today.
Now, you want to serve all the 4 applications to the client? I'll serve all 4. All 4.
Counsel for the appellant submits that. Good. Take out fresh
My
service.
lord, affidavit of service I'm filing.
Respondents and file affidavit of service. Stop for the same. He requires some time. We allow him 2 weeks time. Full stop. Matter is made returnable accordingly.
My lord, this is in Koshba, my lord. May I come back in 1 week, my lord, because I have some urgency. They are proceeding with the execution. May I come back, my lord? I'll serve, my lord. Hand service I'll do, my lord, and I'll
1 week.
I'm grateful, my lord.
There's the procedure for withdrawing. Shop.
About 10.
My lord, item time, I'm praying for not this week because your lordship asked the status of the partition suit before the trial court. For getting that information, I require a few days time, my lord. So kindly take up next week. In the meantime, I'll get status of the partition suit from the trial.
We have a directed in the last order.
No, your lordship had orally asked me to get the status of the partition suit. This is that matter where after the preliminary decree was passed, we had preferred an appeal and that appeal was dismissed for default. And we had filed an application for readmission of appeal. And your lordship was hearing that. Your lordship had looked into the prescription also and told me
For
to.
ascertaining the present status of the suit. Bearing title suit number,
Partition suit.
title partition suit number 38 of 2001.
Yes, my lord.
The Learned Counsel seeks an adjournment to stop. 1 week adjournment is allowed.
Seven.
Well, I am for the appellant. I filed an application for injunction. The other side paid for filing the opposition, but they have not filed. Lawsuit directed me to inform him, but I could not find my lord in the. So lawsuit can adjourn till Wednesday.
Wednesday,
Wednesday, I will search him.
there is an order to intimate them.
And just subject.
In spite of the time granted earlier for filing an affidavit in opposition on 25/2024, there is no appearance on behalf of the respondents when the matter is taken up today. Stop learned counsel for the appellant submits that he would be intimating the learned counsel. Mr. S.K. Humaya Raza.
Sheikh Humayun, he's sitting bar number 4. I'm in
Stop.
5. But
Let
today
him
morning
do
I have
so.
not seen.
Matter be taken up
That's
Wednesday.
fixed on Wednesday.
Monday.
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 Twelve.
12 Lordships, I appear for the appellant's defendant in the matter, Lordship. This is an appeal against an order of the learned civil judge senior division Ranaghat Nodia, whereby the partition suit has been decreed in favor of the plaintiff without declaring the shares of all the parties in the partition suit, Lordships. The present application, Lordship, the court below is proceeding with drawing up the final decree. The application is an application for stay. Lordship will
Can one.
Lordship. Lorships will kindly see the ordering portion. There has been only declaration of the share of the plaintiff in the suit proud in the judgment. Shares of the respective parties have not been ascertained.
Why have you not put in the Talbana costs?
Lordship, I have my mistake, Lordship. I have not checked up if it has not been put up.
It would have been under notice by now.
Lordship, I undertake to put in course of the day, Lordship. Lordship will kindly keep it. Tomorrow I'll put it in course of the day.
Yes, for complying with the report
reported
regarding non-submission of Talbana costs. The learned counsel submits that steps would be taken during course of the day. Stop. Matter is adjourned. Keep it on Friday.
Right. I'm grateful.
Defective, little defective. Defective. It is defective. None appears for the appellants for taking steps with reference to the defects pointed out. Matter is adjourned. Stop. The same may go out of the list.
Oh, 14, my lord, I am for the appellant. I am for the appellant, my lord, in 14.
Yes.
Appellant petitioner. Well, the suit is for partition. Well, suit is for partition. It is ex parte application. It has come for the first time. Therefore, my lord, let there be direction for service and my lord, with the interim order, so that my lord, on the contested hearing, the matter may be decided. The
You
suit for
also have not put in the Talbana cost as per the stamp report.
but I shall put in the Talabana cost. My lord, Talabana cost is relating to my lord knows it. My lord, it relates to my lord service of notice of appeal.
Correct.
And this is my lord application. My lord, appeal, my lord, will be heard subsequently, but the application is required to be taken up for hearing, my lord, early. Therefore, my lord, let there be direction, my lord, to serve the copy of the application for injunction.
Let the learned counsel for the appellant take steps for effecting service on the respondents to stop affidavit of service be filed. Matter is made returnable 1 week to stop. In the meantime, the defect regarding non-submission of Talbana cost shall also be removed by taking appropriate steps.
My lord, I shall.
Yes.
And my lord, only my lord, injunction related not to create any third party interest.
Therefore, it is coming up after 1 week, not adjourning it for 2 weeks.
My lord, it is Midnapur, my lord, Midnapur, Paschim Medinipur, it will take some time.
2 weeks.
My lord, my lord.
2 weeks, yes.
My lord, I am grateful to you. Fifteen, my lord, I am for the appellant. It is arising out of a, my lord, probate proceeding. Probate has been granted, and I have, my lord, filed this appeal stating that challenging the genuinity of the will.
Lordship, Mr. Parthapratim Rai is appearing, Lordship, he is leading me, Lordship. Let us see what is the issue.
My lord, my contention is this, my lord,
Yes.
that the testatrix, my lord, was not in a mentally and physically fit to execute the will. That is
Yes.
the one of the point. And the, my lord, evidence of the PW4, my lord, it is said that the contents of the will was read over by the scribe, which proved that although the testatrix was educated lady, but at the time of execution, the alleged will, she was not, my lord, mentally fit to read out the will. He was a, my lord, educated person. Therefore, my lord, she should not, my lord, she was not in a mental fit condition, and the same was written in Bengali. This is, my lord, suspicious circumstances which is required to be, my lord, proved that the will has been executed by the testatrix herself. And, my lord, the evidence of PW4, Nimai Chandra Khara, my lord, the witnesses put their signatures after signature of the testatrix, which is, my lord, contrary to the evidence of the other attesting witness, who says, my lord, that the attesting witness signed earlier, then, my lord, the testatrix were signed. Therefore, my lord, these are the suspicious circumstances. One attesting witness says that the attesting witness signed earlier. The contrary view has been taken by the other attesting witnesses.
Succession.
Since it is first appeal, my lord, let there be a direction for preparation of paper book, for bringing the lower court record. And, my lord, the appeal will be heard expeditiously.
You have served a copy of the can. Has been
Yes,
served.
my lord, since there is a
Subsection
caveat.
has been served upon us, Lordship. Lordship, so far as Lordship, their submission that appeal will be heard, Lordship, your Lordship knows that from 2009, Lordship, the probate case was pending, and 2014 it was, Lordship, granted in favor of the Lordship plaintiff. Now, Lordship, if you Lordship kindly consider the submission raised by my learned friend, that first of all, Lordship, it was suspicious ground, Lordship, that physically fitness and mentally fitness. Now, Lordship, the learned trial court, Lordship, very well hold that the physical fitness do not required, but the lady, Lordship, who executed the will, Lordship, was physically and mentally fit. And the Lordship husband, who Lordship deposed as PW1, and Lordship other witness, people Lordship kindly consider Lordship page 7. And secondly, Lordship, the attesting witness sign, thereafter, Lordship, the testatrix sign. With Lordship, my learned friends told Lordship before you submit before your Lordship that after the testatrix signature, the attesting witness signed before the after execution of the said will. If your Lordship kindly consider Lordship page 7 of the Lordship impugned judgment. Paragraph 7, Lordship, the witness who Lordship deposed before the land.
Five witnesses.
5 witnesses. Now, Lordship, PW1 Lordship was the Madanlal Khan, who was the Lordship, the husband of the Lordship deceased, who Lordship executed the will. Lordship. PW2 and PW3 Lordship was the attesting witness, and PW4 Lordship also the attesting witness. And Lordship, you Lordship kindly consider Lordship, PW4 Lordship is a retired teacher, and PW3 Lordship is the relative of the Lordship, the deceased. Now 5 witness lordship deposed on behalf of the lordship plaintiff petitioner. Now lordship, the issue framed regarding lordship, issue number 3 at page 7, was Shobha Khan, the executrix, mentally and physically fit to execute the will at the time of execution or not? This is the main question, lordship, before the honorable court, lordship, for admission of this present appeal.
No, my lord, it is first appeal. There is no question of admission. It is not second appeal or first miscellaneous appeal. It is automatic
Because as my
admission.
landed can submit.
Only thing is that my lord, it is required to be heard.
Yes. Now
It is first appeal. Therefore, on merit, it is required to be heard.
Page 10, lordship, issue number 2 and 3, lordship, was considered. It has to be heard for records. And lordship, paragraph second.
Records are required to be called for, and my lord, after preparation of paper book, an appeal may be heard on merit.
At the
Has
top,
to be heard, that is correct.
so lordship, kindly heard my senior lordship, he is appearing in another
What
court,
is to be done? It is already admitted. Has to be decided on merits. It's a first appeal.
so far
You will put in the cost for the.
My lord, my lord. I shall put in the special
Main
messenger
grounds.
cost, my lord. Within a week, my lord, I shall put in the special messenger cost.
I am only submitting, lordship, kindly take up, lordship, page 10.
Why? For what? What will be the
At
purpose?
grounds, lordship, for
Let us
they have
see.
placed before the lordship for
Unless the LCR, the trial court records are here, what can be done? Third learned counsel for the appellant who submits that he would be putting in the cost. Stop. Whereafter the office shall immediately take steps for getting the records from the trial.
My lord, let there be an order of status quo, my lord. It is a joint property.
Sorry,
All the part.
Come.
If they are not submitting the lordship as a messenger cost, lordship, then we will lordship.
He is saying he will submit within a week.
Yes, I shall submit that. My lord, so far the application for injunction, my lord, the application for injunction is there. It is CAN 1 of 2024.
Yes.
My lord, let there be an order of status quo, at least, my lord, to the in respect of the property. My lord, we are all our heirs.
Let the records come, then we'll see.
My lord, in that event, kindly keep the application pending.
Yes, we have not
Kindly-
disposed of the application.
Yes, my lord, kindly direct that the application will be listed for hearing after 2 weeks.
All right, you after 4 weeks, you deposit
After
the
4 weeks. After
yes.
4 weeks, my lord.
The CAN number 1 be listed after.
One thing, lordship, regarding special messenger, if there is no time limit, lordship, department is not.
We have said within a week.
They will lordship come again, lordship, for
No,
extension.
we have said within a week.
By it today itself, I shall pay it. I shall deposit it.
All the more better.
I shall, my lord. I am grateful to alerts.
Number 16. And for the petitioner, this is a case challenging the ex parte decree on the mat suit. It was earlier FMHU, thereafter his lordship.
It has already been.
His lordship was there in the division bench.
Yes. So now it has been a fresh number has been.
Fresh for the mat suit appeal.
FA87 of.
There's a deal in this.
Yes, 353 days.
There's a delay in this.
That is the application.
That is the application.
In this case, the other side, opposite side appear, but today they are not appearing.
This has been served.
Yes, already served. When there is a FABT 468, thereafter number changed to FA 87.
This can 1 has been served.
Yes, everything. Can and can 2, both served.
You have filed an affidavit of service.
No, I have not filed the affidavit of service, but since they appeared, that's why. Let's see, may direct them next day. Because I already served on them, but they appeared on this case. That's what they call.
They are appearing already.
468. FMAT 460 was their earlier number.
After the change of the number, they have appeared or not?
No. This is the first time I got also number.
So how will they know that this is the FN?
The new number. Yes. I thought of it.
Please intimate the council that it is on the list. After the last order dated 6/5/24, the appeal has been categorized as a FA, first appeal instead of first miscellaneous appeal. Stop. In view of this changed circumstance, the learned counsel for the appellant is directed to intimate the learned counsel who has earlier filed his appearance in the present proceedings regarding listing of the CAN application, which is to be considered on Friday, give the date of Friday. You intimate by Friday, we'll keep it on Friday.
It will listed on Friday only.
Yes.
Much obliged.
Give the date of 12th.
Good.
Number 17.
But I pay for the appellant, my lord. But suit for declaration and injunction.
And for the landlord, plaintiff.
The trial court comes to a finding that I am in possession. There are issues which have to be decided in the trial, but refuses to give me an injunction. Order 7, Rule 11 filed by my learned friend also dismissed. My lord, if I may only shorten the matter, my lord will only take up can 2, the order which was passed by the coordinate bench at the time of admission of the appeal, my lord. But the division bench came to a conclusive finding that the decree itself is not prima facie analytic. But the immediate urgency, my lord, the execution proceedings are pending, my lord. The নামটা নেবেন।
Yes.
No, my lord, this is a suit, my lord. I have filed a section 41 proceeding under the, my lord, Presidency Small Causes Code Act, my lord. This is a summary proceeding, my lord. My lord, after that, my lord, if they want to challenge, my lord, they can file a suit, my lord. Now, my lord, they have taken a point of section 19. Lordship will kindly take, my lord, impugn page 3 of the division bench order, my lord. This is the last paragraph. My lord, may I read for your lordships, my lord?
Yes.
Well, our attention has been drawn to section 19 of the Presidency Small Causes Code Act 1882. Section 19D says that the Small Causes Court shall have no jurisdiction in suits for recovery of immovable property. Therefore, prima facie, it appears that the decree for eviction passed by the Presidency Small Causes Court was without jurisdiction and therefore a nullity in the eye of law. We are told that the execution proceeding was started by a decree holder against the present appellant in 2021. Now, my lord, after that, my lordship will kindly takes the last paragraph of impugn page 5. Sorry, my second paragraph impugn page 5. We would have disposed of this appeal, but for the fact that the learned advocate for the respondent defendant says that he wants a few days time to come back and argue before this court that the present appeal is not maintainable and the appellant's plaintiff are bound to pay occupation charges at the market rate to the respondent defendant.
Therefore, we asked you, you had said that you want to argue on the point
Yes.
of maintenance.
Now, first of all, my lord, the submission which has been made by my lord, my learned friend in respect to my lord, maintainability point, in respect to my lord, whether cities, Presidency Small Causes Court have any jurisdiction, lordship will is totally, my lord, dehors the law. Well, I am carrying on the amendment, my lord, this lordship will kindly. Yes, well, I'll just show, man. And a copy them. Each copy আমার কাছে তিনটেই ছিল। Now, well, I'll read by one, man. Now, well, this book, Mala, it's only one copy I have, Mala, because it's a very old version, Mala. I have, Mala, managed to get one book, Mala. Mala, Lordship will kindly seize, Mala, the amendment portion, Mala, 3. In chapter 4 of the Principal Act, section 18 shall be renumbered as subsection 1 of that section, and after subsection 1 are so renumbered, the following subsections shall be inserted. Notwithstanding anything contained in section 19 or subsection 1 of this section, but subject to the provisions of subclause 3 of clause 1 of the first schedule to the West Bengal Premises Tenancy Act 1956, the Small Causes Court shall have jurisdiction to try all suits and proceedings for eviction of a tenant under chapter 3 of the said act as a civil court of ordinary original civil jurisdiction. But this is the amendment, my lord, and lordship will kindly seize. Only, my lord, lordship, I'm just handing, this is only one copy, my lord. 18.2 and 19, it has to be read with. 18.2 is an amendment which has been made in 1999. After that, my lord, and recovery of possession, every suit lies before the Presidency Small Causes Court. And Mala, I have judgments to that, Mala. If a lordship, my lord, is not satisfied with the amendment,
you are giving one copy.
Mala, I have managed to get it's very, Mala, my learned friends have. Now, my learned friend can. Same book, same. This is the second copy, man. My lordship will kindly take, my lord, 18, 18.2 and 19.
18. Have been declared as a citizen. Then it's bad. This is Same point. Same point. You have to begin that they are not, we are doing revision. Yes. Same. Petition.
So what is the pecuniary jurisdiction today?
Pecuniary, there is no dispute. Mala, what they are
No,
taking.
what is it? Because here
2000. 2000.
till today it is 2000.
Mala, আজকের দিনে দাঁড়িয়ে mala, I have to see mala, but 2000 was the rack rent mala. Mala, probably mala, because as per my knowledge goes mala, subject to correction by your lawsuits mala, 2000. It's 2000.
Till date 2000.
There was these are mala, basically mala, if your lordship takes mala, I have not filed a suit.
No, we are.
I have filed a proceeding under section 41, well, which is a summary proceeding, my lord. And mala, it is a duty on the occupant, mala, he will come and he will file a surety. And if he challenges my whatever jurisdiction on my relationship, he has to file a suit.
See, this is a new act for speaking for myself. It is a new act for me.
Yes, absolutely.
Therefore, I am trying to ascertain. You are going on the merits of the matter. I am trying to ascertain the jurisdiction.
Absolutely.
So the pecuniary jurisdiction remains 2000 till date.
Till date, as per my knowledge goes.
No, you can't say as per my knowledge.
Because I could not find any amendment to the my lord, the recent. This is the very recent matter. This is very recent matter. I could not find any amendment.
But I'm told, my lord, it is 60,000 now, man.
60,000.
60,000.
It seems quite. We don't think it should
Very
be
well,
2000.
then it's also good for me, man. Yes.
So this has already been incorporated in
Yes.
in this publication that you have given.
That is the thing, Mala. So, Mala, I could not get back to the amendment on that day, Mala, when this hearing was there, Mala. So, Mala, I just took time before the honorable court that, Mala, I'll come back with all the documents, Mala.
And this has been inserted. It is with effect from 25th October.
Yes.
1999.
Yes.
Can we examine this matter a couple of days from now?
Well, two things, my lord.
Yes.
Possibly this amendment relates to tenancy.
Yes.
I have been described as a licensee. Number one. Number two, my lord, these points have been taken by my learned friend in the Order 7 Rule 11 application, which has been dismissed. Kindly turn to page 83.
Well, I have not completed my argument. Mala, this
No,
was the
Jocha,
prima
আমাকে
facie.
ডাকলো, বলার জন্য।
I was just because we would like to go through this. Therefore, we are asking you that let it come after a couple of days.
My, the only thing is whether the execution is fixed tomorrow.
What will happen in 2 days?
But then let my learned friend take an adjournment.
I'll have strict objection in respect to
But
execution.
kindly seize the order, my lord. To dekhi.
Let him put some money, my lord. I am suffering.
No. My lord, kindly see the order passed by the executing court, my lord.
Well, I have not been served with the order, madam.
না দাঁড়াও না ও execution করে
Lord, kindly sees the last line, my lord.
No penal action is there.
So let my learned friend take an adjournment, my lord, in view of that.
Taken an adjournment.
My lord, kindly fix, can take out.
No, this order was passed in spite of High Court's order.
High Court's order was
High
not.
Court's order 26
And this order was passed in the tooth of the High Court's order.
Well, I have a second limb of argument, my lord.
All right, then we'll consider today.
Well, only one thing, my lord. Well, I have a second limb of argument, my lord.
Yes.
My second limb of argument is that, my lord, well, I have initiated a proceeding under section 41 of that, my lord, act. It's not a suit. Well, may I, my lord, submit, my lord, section 41 is a summary proceeding. Lordship will kindly read section 41 once, ma'am.
Let us see, first give
Well,
us the
section
relevant
41
facts. Just wait. You give us the relevant facts. What are the relevant facts?
My lord, the predecessor in interest of the appellant, my lord, appellants, but initially filed a suit, my lord. No, my lord filed a suit for declaration and injunction, my lord, before the city civil court. My lord, by a decree of 2001, my lord, the suit was decreed in favor of the predecessor in interest of the appellants, holding him to be a lawful tenant under the
2001.
2000.
What is the date of the decree?
My lord, that is my sorry, my lord, the date is September 10, 2007, my lord. It's at page 14, my lord, of the stay application.
September 10,
2007. Page 14 of the stay application, my lord. But the relevant portion is at page 16, my lord.
Page
16. Page 16, my lord, the relevant portion.
This is the 2007 decree.
No, my lord, this is the 2007, my lord.
2007
of-
decree. They have
2007 decree.
just give us a minute.
Yes.
Come to the third paragraph at page 15.
My lord.
Your case was that you are a tenant under defend number 7.
My lord.
Occupying one room. Along with the defend number 7.
Yes.
And thereafter,
But the defendant number 7 goes, my lord. My lord, this order was passed in respect of the previous owners of the property. Because my learned friends has come into the picture in October 2011 by dint of purchase of the
but
property.
it says you started paying rent to defend number 7.
Yes.
Well, I was not made party.
Just a minute.
No, he couldn't have been because he purchased the property in
I'm
2011.
asking you just to clarify the facts from this paragraph.
Page 20.
Is it coherent? Plaintiff, thereafter, the plaintiff started living separately with the defendant number 7 in 1971. While she started living in separate mess, he tendered rent to the who tendered rent to defendant
But
number
the plaintiff, my lord, in that suit, my predecessor in interest.
So therefore, who is the other party? We can only see the plaintiff and defendant number 7. Who is the other party?
Roots property is different. Roots is one.
My lord, my lord will find the defendant number 7, my lord, at page 22. She's a aunt of the predecessor in interest of the plaintiff, my lord.
You are claiming to be in joint possession with her, and you are.
But after that, my lord, the defendant number 7 goes. She goes out of the property.
No, but you say the plaintiff start tendered rent to the separate mess. He tendered rent to the defendant number 7.
But after that, the defendant number 7 goes. Then I start paying rent to the landlords. Rupok Shen, if my lord sees the original landlord, my lord. Original landlord.
The plaint is at which page? Annexure B.
No, the plaint of this suit is not annexed, my lord.
But this fact is not clear from this paragraph. What you are trying, what the court is recording. Just read it once. See if you can make sense out of it. You say you are a tenant under defendant number 7, then you say you occupied one room jointly with defendant number 7, and then you say you started paying rent to defendant number 7. What is your relation with defendant number 7?
Defendant number 7 is my aunt. She was a tenant. She was a tenant, though. She was a tenant.
Then how can you pay tender
But
rent
there's
to her?
possibly, my lord, some typographical error, my lord.
No, so therefore we are trying to determine, it's for you to clarify. You claim in the same breath to be a tenant along with defendant number 7 and to be paying rent to defendant number 7. How can it be?
But this possibly, my lord, but if my lord kindly.
Sir, we want to know. Unless we understand the facts, how do you
Well, the defendant number
suppose that we should proceed?
Well,
Not on the basis of submission. The facts have to be clear.
But I was a licensee.
We are subtenant, then applied for tenancy.
But we were subtenants under the 7, defendant number 7.
Subtenant is claiming in the.
Can you make out this fact from this paragraph?
But this.
If you can, then please.
No, there are subsequent orders by the rent controller also.
This is the decree. Taking note of the facts, you are relying on this.
My lord.
Now this records facts which we want to be clear with. You are claiming your status based on this decree.
My lord, then kindly comes to page 22 once, my lord, this subsequent order by the rent controller. There also, my lord, this issue was there, and the rent controller also helped me to be a lawful tenant.
What is your case? You tell us.
But my case is, my lord,
jumping from one order to the other, you tell us what.
My lord, my case is, my lord, I was declared a lawful tenant by the City Civil Court as well as the learned rent controller. My learned friends, my lord, came into the picture in 2011. My learned friend, my lord, files a suit for my eviction before the Presidency Small Causes Court as licensees, my lord. That suit, my lord, is decreed in favor of my learned friend.
You are still not clarifying this.
But I challenge that decree, my lord, by way of the present suit. That is permissible under the Presidency Small Causes Act. That is also a prayer, the first prayer in my plaint, my lord, which is at page 55.
So far as the threatened eviction is concerned, you can resist. Or you could have filed an application there.
But whether the proceedings, but whether the proceedings itself is maintainable before the Presidency Small Causes Court, that is itself the first prayer in the plaint, my lord, challenging the decree passed by the Presidency Small Causes Court. And if my lord kindly comes to the impugned order, the court has found that I'm in possession. My possession is required to be protected. There are materials which shows that the suit has to go to trial.
Let's see this order first.
If
you are not able to clarify, we'll try to make sense out of it.
Page 34, entire thing has been clarified.
You are the person who has sought the decree. You cannot make sense out of it. How do we make sense out?
Page 34, entire thing has been clarified.
But I was a subtenant initially under the defendant number
Can
7.
you make out that from the?
But that, my lord, I cannot improve on what has been written in the
But
order.
the facts have to be clear. What is your status vis-a-vis defendant number 7? Insofar as
But
defendant number 7, you are saying both things. That you are a joint tenant with defendant number 7 and that you are paying rent. How can
My lord, the situation as is now, my learned friend has accepted me to be a lesser in that in respect of the suit premises. Hence, he has filed the suit for eviction. He accepts me as a lesser.
That suit was after this.
Yes.
All right. So
Much
let us
after
read
this.
just a minute.
Much after this, my lord. No, cryptic আছে এই অর্ডারটা না cryptic আছে
in total declare to which that if the licensee take application for proper application for declare status so যারা করেছে তাদেরকে declare করে tenancy something it's
page the rent control In fact, my lord, page 25 will clear what your lordship was asking me, my lord. The second paragraph.
original page not some check.
Page 24.
25, my lord. The findings of the rent control in paragraph 2, my lord. বলছি page 24
They did not come out. So that much is from that. Yes, that's eviction. After that, it's 23. I think I did it.
So Ruth Gomes was defendant number 7.
Yes, ma'am. Ruth Gomes.
22.
That's at page 22, man.
Now it is clear.
Yes.
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 So you are declared as a tenant.
Yes. Accurate. Was that?
What is the date of this order?
But date of this order, my lord?
Yes.
The date of this order is
28/10/14.
yes, October 28, 2014, my lord.
Yes.
But after that, my lord, my learned friend files a suit in 2014 before the accurate, before the Presidency Small Causes Court, treating me as a licensee and asking for my eviction. Well, that suit was decreed by an order date judgment or decree dated, my lord, December 23, 2019. By an order dated, my lord, December 23, 2019. That's at page 26. That একটা প্রত্যেকটা document দেখছি। That's at page 26, my lord. 23rd December 2019. Page 40, my lord, is the operative portion of the order. Order বলছি না।
Page 41.
40 is the operative portion of the order, man.
Yes.
Yes. My lord, kindly turns the next page, my lord. I immediately file a suit, my lord.
This
Before
is
the
23/12/2019.
19, my lord. But I immediately filed a suit in 2020 before the City Civil Court, challenging, praying for declaration and injunction, as also, my lord, challenging this decree passed, this order, my lord, passed by the Presidency Small Causes Court. My lord, will kindly see my prayer, my lord, which is at page 55. The first prayer is, my lord, that. Page 55.
Yes. What is the order?
But this is the prayer, my lord. I also filed an application under Order 13 and Rule 1 and 2, my lord. Initially, my lord, ex parte interim order refused. I come up before this High Court. There was a limited stay on the execution. Ultimately, my lord, this court directs the learned City Civil Court to dispose of the injunction application. Here, my lord, what is pertinent is my learned friend had also filed an application under Order 7, Rule 11 for praying for dismissal of the suit, contending the same contentions which my learned friend raised before Lordship a few minutes ago. My lord, this kindly see the dismissal order of that, my lord. That, my lord, order starts at page 83. The Order 7, Rule 11, this has been unchallenged. Page 83, my lord. সেটাই is with us. That was same please not. Yes.
Yes.
But two relevant portions of this order, my lord, if I may just indicate,
Page 86, my lord, the third paragraph, and page 87, the second paragraph. The suit is maintainable.
Yes.
My lord, now kindly comes to the impugned order in this appeal. My lord, we'll find that at page 103. March 2024, my lord.
The second last paragraph of this order is the reason assigned for not allowing the
Yes.
application under Order 39, Rule 1. At page 105,
My lord.
the last but second paragraph.
But that prima facie evidence to suggest.
Yes.
But the execution of proceedings, my learned friend has already started. And today, if he evicts me, my lord, what else is to be there done in the suit?
Where is the order passed under section 26 of the Tenancy Act?
26. My lord, that's at page, my that's the page 22, man. Now the relevant portion, page 25. Page 22, my lord, it's at relevant portion 25. And this order was not challenged by my friends, my lord.
This is by the rent controller.
যেদিন থেকে আইনটা এসেছে 2001 you have the option was given 240 days এর মধ্যে to apply before the rent control claiming the tenancy. That was done.
But this act, my lord, if I may just add one sentence, my lord, this act came in force in 2001. And my lord, that notification had been issued at that point of time, my lord. Within 240 days, if you can apply before the rent controller.
Yes, that fact has been considered in the order. We have seen that. It has held that it is within the 2 years
Within
and
the
2 months both.
Fine. Great.
That declaration under section 26, whether it has been considered in suit number 52 of 2014?
Yes, yes, yes. Yes, my lord, I'll show you your lordship's the 52 my total exam. Page. One for paragraph.
Page 34. 33 থেকে start. দুটো already
But kindly takes up pages 33 onwards, my lord. The reference of the RC case is there, my And my lord, page 34, my lord, the second but one paragraph, my lord, will show, my lord.
The antiphysins is the successor in interest of the person in
Yes,
respect of
yes,
whom you got the
yes,
declaration
yes,
under 26.
Yes.
that has been written. That has been written.
Yes,
So,
you
you
take
know,
it.
I get it. But 26 has been filed after filing of this application.
It's a different.
Just wait.
The partition 2011.
October.
No development of
Page
29.
E.
Oh, no. Plenty is the purchaser of this. 29 bottom. কোনটা দেখছি? Page 28.
October.
The defendant in case number 23 was also party to this small cause courts.
No. Because, my lord, he had purchased the property in 2011. That is also reflected at page 29.
Page 28 bottom. We did not have no notice of it yet. The plaintiff last line.
2011 to likha hai, 2001 bolche.
2011. Right?
But the last line of page 28, my lord. Kindly sees 2011, my lord, the property had been purchased.
No notice of tenancy was given. That auction was a partition of 6 purchase.
And no notice of the purchase was received by us.
And what has this small cause court held with relation to the declaration under 26? What is the finding on that?
The small causes court.
Yes.
But that is at page.
The page 33 onwards, my lord, Lordship will kindly take.
Please, you allow him to.
33.
But may I read that portion, man?
Which page you are?
Page 33, man. My lord's got it. My lord, the defendant has banked upon the judgment and decree of title suit number 1878 of 2001 and the final order of RC case number 23 of 2002. Learned advocate for the defendant in his argument advanced that when proceedings before the rent controller was pending, the so-called license was granted and terminated, but the plaintiff did not approach the rent controller. Drawing my attention to Exhibit C, advocate for the defendant further put forth before this court that the rent was deposited in the name of the plaintiff by all the tenants. Once the defendant has been declared as a tenant, this question cannot be revisited as it is barred by the principles of res judicata. Neither the decree of title suit number 1878 of 2001 nor the order of RC case number 23 of 2002 was challenged by the plaintiff. The birth certificate, ration card, voter card of the husband of the defendant would go on to show they were in long possession of the suit premises. The story of granting license cannot be believed. Learned advocate, relying upon the judgment reported in so and so, concluded the defendant is a tenant in the suit premises, so the plaintiff is not entitled to get the decree as prayed for. Per contra, learned advocate for the plaintiff in his argument advanced that the decisions of title suit number 1878 of 2001 and RC case number 23 of 2002 are not binding upon the plaintiff as she was not a party to those proceedings and it was filed behind the back of the plaintiff in connivance with Ruth Gomes. Relying upon the decision reported in such and such, learned advocate submitted that the fact brought into the notice of this court by PW1 remained uncontroverted as it was not challenged in cross-examination. It is fact that there is a declaration of a court of competent jurisdiction that the husband of the defendant was a tenant under the vendor of the plaintiff. It is also a fact that the said decree is still in force, remaining unchallenged from any corner.
And what is the time at which point of time,
my lord,
this premises is said to be purchased by the plaintiff of this?
2011, my lord. That is at page 28. Last line.
2011.
Yes, my lord. Kindly see page
2001.
2011, my lord. Kindly see page 28, the last line. The last line, my lord.
Very correct, my lord. It's 2001. The typographical mistake.
No, my lord. How can my lord kindly sees the?
I'm showing from the print. Showing from the plate.
But if the plaintiff had purchased the property in 2001, the initial suit could not have been filed against Rupok Sen.
Page 28. The plaint is here. The plaint is here.
Yes. Mala, for your lordship, Mala, I have bought it. Mala, 2001 I have purchased. And my lord, it was there. Mala,
let us see the plaint. Here you search.
Mala, paragraph 3, ma'am. Mala, it is marked. Mala, it's a. Mala, will kindly excuse us, Mala.
So from where this date of 2011? What is the
Mala,
date?
that is the lordship will kindly. This is my plaint, Mala. Lordship will kindly says paragraph 3.
Yes, we are looking at that. Come to page 28 of the application.
Page 28, Mala.
Bottom line, it says 2011.
No, Mala, lordship will kindly take page 34 bottom.
So therefore, we are asking which is the correct date, which is the admitted date.
Correct date, my lord. Lordship will kindly take page 34.
Was there a dispute regarding this date before the small
there is
causes
no
court?
dispute. This is a typographical mistake.
My lord, the fact that they had purchased the property in 2011 would also be borne. My lord, kindly takes up page 29. They claim that the notice of eviction was given in 2012. If they had been sitting there,
something, my lord, he's beyond the record.
Please. Yes.
but if they had purchased in 2001, my lord, my suit, which the predecessor in interest had filed in 2001,
Where is your WS filed in the small cause court?
in the small causes court.
Yes.
WS
Show us
But
that
that's
you have
possible.
whether that fact was disputed. They
But
have
that
clearly
is-
stated in paragraph 3 that it was purchased in 2001. 13/10/2001.
But
Now
that
just
we-
show us from your WS.
Page 34 in the impugned order, it is reflected by the learned.
Just wait.
But that is not annexed, my lord. I have to get that.
Where
one.
you have a copy?
My lord, you have a copy. I have a copy, my lord. 52 Paragraph 3 টা কিভাবে delete করছি তখন না জানি।
What is the date of the sale deed?
Date of the my lord?
Is there a deed of sale?
Yes. Deed of
What is
sale.
the date?
But kindly see how I have dealt with paragraph 3 in my WS. That's at paragraph 11. Even if, my lord, what my learned friend claims now, it has been brought in 2001. My suit of 2001 was against the original landlords, original owners, my lord. My learned friend could not have been, should have been made, he should have been.
So this is a fact not denied by you. You say not intimated to us.
But we were not intimated the date of purchase, my lord.
The fact not denied by you. You could have said that this is not a fact, or it is incorrect, or it is denied. You say we don't, you never told us. So if that be the question, then they were a necessary party. While the matter was being considered before the rent controller under section 26, if you have obtained a declaration without impleading them, then will they be bound by the decree or the declaration made under section 26? Let us see section 26.
But all these details, my lord, has to be gone by the present suit, my lord.
So
Whether
you are
the
making out
applicability of-
it is for you to make out a case under order 39 rule
My
1
lord.
and 2.
My lord.
Therefore, we are trying to see possession may be something, but whether that possession is founded on a right and which needs to be protected, or it has been obtained by some kind of misrepresentation or
Because,
which
my lord,
needs
if
not be-
today, my lord, my
So let
tenants,
us see what is section 26. Who are the necessary parties? Because the small causes court has taken note of this date.
small causes.
You come to page 34, last paragraph.
Yes. My lord, page 34.
Yes, see the last paragraph, what has been
My lord.
held.
Here it says 2001. My lord, kindly once.
No, please read what it says, sir. Just don't read the date. This is the reason.
Admitted position is the plaintiff was not made a party to these proceedings. Plaintiff purchased the suit premises on
Yes.
13 January 2001.
Yes.
Well, this issue itself is under challenge, my lord, because if my lord kindly sees the documents which my learned friend had exhibited, page 32.
No, it may be under challenge, but the point is, if this is a fact not disputed by you, then why did you obtain this declaration under 26 in their absence? And based on such a declaration, you
was-
say I have a prima facie case to
Because my
protect
lord,
your possession.
we did not have any knowledge of their purchase, my lord, whether it is in 2001 or 2011. The deed itself has not been exhibited. My lord, kindly sees page 31. The deed itself has not been exhibited before the learned presidency small causes court. No notice.
So where is your plaint filed in these proceedings?
This proceeding, my lord, that is at page. My lord, page 41, my lord, it starts. Page 41, my lord. কি? হ্যাঁ, সেটা তো বললাম।
Paragraph 7 টা পড়ো। Paragraph 7 টা পড়ো।
And my knowledge, my non-knowledge merit has also been pleaded in paragraph 7, my lord, page 47. No, it's correct.
7, 8, 9.
And what is this notice that you claim to have served on the opposite party number 126 on 7/12/2001?
But which
In paragraph 13 of that
13.
213, 2 subpara 13.
Page 46 I noticed that.
46. No, this is in connection with the RC case number. Opposite parties of that RC.
But this is in connection with that proceeding before the rent controller.
So what is this? Notice is contemplated under section 26.
No, no. A direct tenant package.
Because this person was not a party, you are relying on this fact that we had sent notice which remained unclaimed and therefore it is now
No,
binding on.
So
So what
no,
is
my
this
lord,
notice?
this notice is in respect of the opposite parties of the rent controller proceedings, my lord, which is
Correct. Because they were not parties.
My lord.
To the proceeding, you say that we have issued notice.
My lord.
What is that notice issued by the rent controller?
But that's a communication of the proceedings of the rent controller, my lord, to the parties before.
Is there any statutory procedure which says once you issue such a notice and it is not claimed or not received, then you can proceed for declaration under 26 in their absence?
My lord, under the General Clauses Act, my lord, subject to correction, my lord, a notice, my lord, if refused or unclaimed, my lord, is deemed to be a service, my lord.
Point is, they were not parties to the proceeding under 26.
My lord.
So any notice divorce those proceedings, will that be sufficient?
But
or once they are parties and notice is issued and they fail to appear, then it will be.
But before the rent controller, my lord, I had no knowledge that my learned friend had purchased, if at all he had purchased. Because there was no communication, there was nothing.
All right, so therefore there is no such procedure in the.
No, and my learned friend, my lord, could have challenged that order of the rent controller if he was not aggrieved by it. He was that he was not made a party. That order was passed in 2014.
Page 45. Page 45. That's the order. After the original notice to 1 to 6. That's the earlier plan.
আমরা কি করে জাস্ট করছি
1 to 6.
No, সেটা কি 1 to 6
No, Matrimonial losses clarification, my lord.
Will not pass an order without hearing you. Please.
Yeah, my knowledge person came from that one.
Yes.
But my kindly sees, my lord, paragraph 7, my lord, page 47. But my knowledge of his having purchased comes only first time in 2014 when he files that suit before SCC, before this small causes court. There has been no communication, nothing by my learned friend to show that he has purchased the property.
Paragraph 7 at page 47.
47, my lord. I've pleaded that in my plain, my lord.
You are not saying you didn't have knowledge.
But I didn't have knowledge, my lord, because no document was submitted by my learned friend. My knowledge comes for the first time in 2014 when he files that suit before the Presidency Small Causes Court.
Yes. Yes, that's all.
Great. My lordship will kindly text, my lord. First, my lord, I'll just, my lord, read, my lord, once the rain controls order, my lord, because that is the order, my lord, my learned friend was placing. My lord, at page 23. My lord, this order has been passed on 28th October 2014. My lordship, my date is very important. Well, why I'll just come back. But this is an application under section 26 of the West Bengal Premises Tenancy Act, filed by Dennis Gomes, lot of late Malab Francis Gomes of 9 Komedar Bagan Lane, Mala Taltola Mala, the applicant subtenant since disease substituted Mala Mr. Juliet Gomes, Mr. Ojit Michael Gomes, Snigdha Francia, and Mala. Yes, Snigdha Francia Mala Thakur Lane, and Mala after that Mala Rupak Sen, Kalpona Sen, and Chitra Molik Mala. These are all the parties. Now Mala. Landlord opposite parties appeared on 9th April 2002. Mala last show will kindly mark the date. 28th May 2002, 5th July 2002, and 28th August 2002. Thereafter, they did not appear throughout the proceeding. The original tenant also did not appear throughout the proceeding, in spite of service of notice of substituted service by an advertisement in daily newspaper. Dennis Gomes adduced evidence in form of affidavit in chief stating that he is a tenant under opposite party number 7, Raut Gomes, in respect of one room partition in 2 veranda and privy and at ground floor premises number 9, Komedan Bagan Lane, Taltola. In support of his claim, he produced rent receives exhibit number 2, MO receives exhibit number 3 series, copy of notice, so and so much electricity bill. Now the applicants prayed to this bench to declare them as direct tenant under the owner landlord opposite number 1 to 6, and they also prayed for fixation of fair rent. Considering the above evidence, it appears from the exhibit 4 and 5 that the applicant sent notice under section 26 to the opposite party landlords. The date of giving notice to the landlord and tenant well within 2 years of commencement of West Bengal Premises Tenancy Act. The case was filed on 5th February 2002, which also falls within 2 months from the date of the issue of the notice. I therefore find the case was duly filed within the time frame, and after observing the statutory provisions due on part of the subtenant as depicted in West Bengal Premises Tenancy Act 97, it is obvious that the tenant who had already subtenanted premises with or without the consent of the landlord would not be interested to serve notice to the landlords for the purpose of regarding the subtenancy as technically direct under the landlords. It is revealed from the above evidence that the original appellant subtenant Dennis Gomes have been in occupation of the suit premises since 1955 in joint mess with Ruth Gomes, who was the original tenant. It is evident from the rent receipts exhibit 2 series that original tenant Ruth Gomes created subtenancy in favor of Dennis Gomes since May 1953 with or without the consent of the main landlord. It is also evident from the decree and judgment dated 1878 of 2001, exhibit 10, that the original applicant Dennis Gomes is a tenant in respect to the suit premises. In view of the above, the subtenancy of the applicant should be regularized as direct tenant under the section 6. Now, on the next para, this order has been passed. 2014 October, this order has been passed. Now, Lordship will kindly see the affirmation date of my section 41, where I have given notice. It's on 20th March 2014. Well, even for argument's sake, if I take all these affidavits have been filed on the basis of 2002 documents. Well, why they have not filed the current documents, man? Well, they are taking a plea that they have complied, but they did not know about the subsequent purchase of the landlord. Well, may I ask this question to myself? Well, based on the old documents of 2002, well, they have filed an affidavit.
What
Well,
is the scope of section 26? Just 1 minute, please.
The consent is the most important thing, man. May I ask this question to myself? But there was no consent. Well, I purchased in 2001, my lord. Well, they have not proceeded with the RC proceeding. And when I filed this, my lord, section
No, no,
41.
consent is 26(2).
Yes, madam.
Come to 26(2).
Well, where before the commencement of this act, the tenant has, with or without the
Or without consent,
yes,
yes.
my lord, sublet any premises either in whole or in part. The tenant and every subtenant to whom the premises has been sublet shall give notice to the landlord of such subletting in the prescribed manner within 2 years of the commencement of this act, and shall, in the prescribed manner, notify the termination of such subtenancy within 1 month of such termination. Where in any case referred to in subsection 2, there is no consent in writing of the landlord, and the landlord denies that he gave any oral consent, the controller shall, on an application made to him in this behalf, either by the landlord or by the subtenant, within 2 months of the date of the receipt of the notice of subletting by the landlord or the issue of the notice of the subtenant, as the case may be, by order declared that the interest of the tenant in so much of the premises as has been sublet shall cease, and that the subtenant shall become a tenant directly under the landlord from the date of the order. Now, madam, my first question is that 2001 suit was filed behind my back, and it is in respect to a different suit property. That your lordship will find it in the judgment. For that reason, I was from the first initial point, I was trying to show page 34 onwards. It's a totally different property.
Section 26 order is in respect of a different property.
Different property. Yes, lordship will kindly cease.
But that has not been considered in the order.
I have purchased 2000 in 2001. What
From where do you say it is a different property? How that is not considered in the impugned order.
Exactly. Well, I'll come. Lordship will kindly take from page 34. Well, I'll read 4 pages. Just 4 pages for your lordship. Par contra, learned advocate for the plaintiff in this argument advanced that the decision of title suit number 1878 of 2001 and RC case number 23 of 2002 are not binding upon the plaintiff, as she was not a party to this proceeding, and it was filed behind the back of the plaintiff in connivance with Ruth Gomes. Well, relying upon the decision reported in 2018, volume 3 CHN, learned advocate submitted that the fact brought into the notice of this court by PW1 remain uncontroverted, as it was not challenged in cross-examination. It is a fact that there is a declaration of a court of competent jurisdiction that the husband of the defendant was a tenant under the vendor of the plaintiff. It is a fact that said decree is still in force, remaining unchallenged from any corner. Now, this was the issue that was going to be decided. But the question is whether the decree is binding upon the plaintiff. Admitted position is that plaintiff was not made a party to those proceedings. Plaintiff purchased the suit premises on 13 January 2001. The title suit for declaration was filed before the purchase of the plaintiff, but it was pending for a long time and disposed of on 10th September 2007, that is after the purchase of the suit premises by the plaintiff, but this plaintiff was not implicated in the title suit. The proceedings before the rent controller was filed after purchase of the plaintiff. Learned advocate for the defendant considered that the rent was deposited in the name of the plaintiff before the rent controller. Exhibit C goes to show that in column number 3, name of the plaintiff is mentioned. Very important, man. But it is surprising enough that the plaintiff was not made party to the RC case. Her name is not found from the cause title of the petition of RC case. So this court failed to understand what restrained the plaintiff and the petitioner, title suit number 1878 of 2001 and RC case number 23 of 2002, respectively, from impleading the plaintiff of this case in those proceedings, even after having knowledge of such purchase of the plaintiff. There is no explanation in this respect by the defendant. It is a rule of equity. One who claims equity must come in clean hands. Equity demands fairness not only from the plaintiff, but also from the defendant. He had committed an inquiry shall not have equity. A person who does not come to the court with clean hand is not entitled to be heard on the merit of his grievance. The court is not duty bound by the judgment and decree of title suit number 1878 of 2001 and RC case number 23 of 2002 to protect the unscrupulous defendant who did not have any respect for truth and who tried to pollute the stream of justice by resorting to falsehood or by misstatements by suppressing facts. The DW1, well, this is very important, in a cross-examination, has admitted that there are 4 buildings at 9 Komedan Bagan Lane, out of which 2 are situated at north side and rest 2 are situated behind them, and the suit premises is situated in the northeast portion. Even if a tenant surrenders his tenancy, the subtenant, if not vacated, automatically becomes an unauthorized occupant. It is also not the case of the defendant that entire 9 Komedan Lane was let out to Ruth Gomes. Moreover, the principles of res judicata is not applicable to this case, as the plaintiff of this case was neither a party to the former proceeding nor the matter directly and substantially in issue in this suit has been directly and substantially in issue in this suit, nor it had been heard and finally decided in that suit, nor it relates to the northeast portion of 9 Komedan Bagan Lane, which is the subject of dispute in this case. Accordingly, the decision relied by the defendant is not applicable to the instant case. Actually, it has become crystal clear from the admissions of DW1 that previous proceedings were filed by her husband in connivance with Ruth Gomes.
Yes,
May I continue, my lord?
we'll come back.
My lord, one matter, item number 13, when it is called matter, I could not appear before your lordship, my lord. Your lordship, my lord, out of list. Kindly not today, my lord. Kind.
My lord, she will continue at 2 p.m. Great. Just continuing, my lord. The lordship will kindly take from page 36 for the sake of continuity, my lord. Last paragraph. Yes, page 36, my lord. Yes. Lordship has got it, well. Well, moreover, from the third paragraph. Well, moreover, the principles of res judicata is not applicable to this case, as the plaintiff of this case was neither a party to the former proceedings nor the matter directly and substantially in issue in this suit has been directly and substantially in issue in that suit, nor it had been heard and finally decided in that suit, nor it relates to the northeast portion of 9 Komedan Bagan Lane, which is the subject matter in dispute of this case. Accordingly, the decisions relied upon by the defendant is not applicable to the instant case. Actually, it becomes very crystal clear that from the admissions of DW1, that the previous proceedings were filed by her husband in connivance with Ruth Gomes. The DW1 in her cross-examination has admitted that her husband used to reside with Ruth Gomes since 1955 and she had been residing at the house of Ruth Gomes since after her marriage 1968. At one side, the DW1 said he does not know whether Kangshan Bano was made party to the title suit or to the rent control case. Well, this Kangshan Bano is the plaintiff, the respondent before your lordship. To the rent control case, on the other hand, she deposited rent in her name, Kangshan Banu. So, well, rent was deposited in favor of Kangshan Banu. But the DW1 admitted that nowhere in the rent receipts deposited by her, the word northeast portion is mentioned. She also, yes, Mala, they have deposited. So, Mala, the point, Mala, why I was showing before your lordship, Mala, 2 points. Well, they have taken a specific point before your lordship that the RC case, they did not know the name of the anybody, Mala, whatever who has purchased. I purchased since 2001. But after that, rain control. They have made a slip, Mala. This is subject to, Mala. Well, I am not on that, Mala. This is their submission. What the court has found. No, well, I'll just read. Well, only 2 pages, lordship kindly allows me. The DW1 in a cross-examination has admitted that her husband used to reside with Ruth Gomes. Now, next para. At the one side, DW1 said he does not know whether Kangshan Banu was made party to the suit or rent control case. On the other hand, she deposited rent in the name of Kangshan Banu. But the DW1 admitted that nowhere in the rent receipt deposited by the word northeastern portion is mentioned. She also admitted that there are 4 buildings at 9 Komedan Bagan Lane. I have examined very carefully each and every document of the defendant, and nowhere from that documents it is found that they related to the northeast portion of 9 Komedan Bagan Lane. The DW1 in her cross-examination has categorically admitted the suit premises is the northeastern portion of 9 Komedan Bagan Lane, but the word northeast portion is not mentioned in exhibit J, K, L, M, N. Rather, she admitted that she failed to submit any document to show that the suit premises is not northeastern portion of 9 Komedan Bagan Lane. Why I am showing this is suit, what the suit they have, they are alleging that they have got a decree that is in a different suit property. The PW1 in her cross. This earlier title suit also, my lord, if I take, my lord, 1 point, my lord, from their submission, my lord, they are, my lord, good, bad, indifferent. They are saying that they have obtained a decree, my lord. Well, first of all, my lord, I was not made a party in spite of the fact, my lord, I have purchased in 2001. Second is that, my lord, suit property is different. But today, my lord, they have come before your lordship, my lord, in respect to execution case, well, where I have obtained a decree under section 41 of the, my lord, President Small Causes Courts Act, my lord, that is a summary proceeding. Well, occupation, today, lordship, today, even if that's a different manner. So, what they were trying to show is the connection. Now, only one thing, I was just showing from this order, even order 7 rule 11 might reject. Now, then there is no threat. Now, if your lordship, I will be, then, taking my argument on a different note, if today, your lordship is, allowing their prayer for stay, then, I will, only relate to that, Atmaram Properties and Anderson Right, where your lordship has to put on terms. Nothing. Rent is a different thing, or occupation charges. No. This is the only issue I'm before a lordship. Lordship will, lordship's view, if today, if lordship will kindly allows you, two things, they have taken a point of RC case, that has been demolished. 2 cases. Now, what is in this? Very well. But then what is in respect to this suit property? Well, if today, I got, but this is not, lordship, this is all on record. From the cross-examination, may I ask this question to myself, today, if somebody admits before a court, it need not required to be proved. An admitted position need not required to be proved. Now, if I take this order as it is, now, what is section 41 and what is section 18 of the Presidency Small Causes Code? Yes, your lordship has, I was giving a reply, may I? I was not given an opportunity. For the first time, lordship will kindly take, yes. Today, what has my
Only because of the execution, my lord. That's the only reason. My lord.
Yes. My actually. Today, my lord, my learned friend has come before your lordship in respect to praying for an stay of the execution. Yes. Now, lordship will kindly take section 18 first with section 41 of the act. I have handed it. Yes. Now, lordship will kindly see section 18 once, section 18 is a suit. My argument is that question has arisen before this honorable court whether a suit is maintainable or not. Section 19, section 18(2) takes care of 19. 18(2) takes care of 19. Now, she will kindly see. Now, this is under notwithstanding. So, this is a suit under chapter 2 or 3 of the act. Now, lordship will kindly takes chapter 7 of Presidency Small. That is section 41. Lordship, my application is under section 41. From the first initiation, I have pleaded with your court, section 41 is a different proceeding. 41 is a summary proceeding. Once 41, I have served a notice. I'll clarify. Very well. Give me 2 minutes of time. Section 41 is a summary proceeding. What a tenant has to be do or a occupy or anybody under the who is residing or occupying that premises, he has to file a surety before the court. Taking the plea, then I'll go and file a suit for declaration. That is section 47. Stay of the proceeding on occupant during security is being against the applicant. So section 41 and 47 has to be read it with together. Once I give him a notice under section 41, I'll clarify, I'll come back. No, this is not a temporary injunction. What I'm praying before your lordship, this is a contested one. My lord, what has fallen from your lordship? What lordship? If today his initiation of that first suit is bad, then he cannot pray for an injunction. My question is in respect to the filing of this appeal. He has taken a point. Give me 2 minutes. Kindly, I'll try. His point is that the suit is maintainable or not. That is the question. My contention is that I have given your loss. Which one? Even if today your lordship takes from that point also, I am on his filing of suit. Lordship will kindly take a look at section 47 and 41. 41 is not a suit. I am carrying a Supreme Court judgment of yes, section 47 lordship will kindly take whenever on an application being made under section 41, the occupant binds himself with 2 sureties in a bond for such amounts as the small causes court thinks reasonable, having regard to the value of the property and the probable cost of the suit. Next, hereinafter mentioned, to institute without delay a suit in the High Court against the applicant for compensation for trespass and to pay all the cost of such suit. In case he does not prosecute the same, in case the judgment therein is given for the applicant, the small court shall be proceeding on such application until such suit is disposed of. This is once I serve him a notice, it is his duty to come before the court and put a surety, and then he can file a suit. But in a situation, he has contested section 47. His right to challenge that order has been waived. My order 7 rule 11, if today rejected also, my lord, if he has taken a point before your lordship sitting in an appellate jurisdiction, my lord, lordship can always take, this is a point of law. If today his filing of suit is bad, the injunction application, whatever the application he files in respect to that, that also comes to a zero. Nothing. My contention is that it is not a suit under section 18 or chapter 2 of the said act. It's a summary proceeding. He could have filed an application or suit once he gets the notice of section 41 in 2014. He has contested the same. Now he is seeking an order of injunction, good, bad, indifferent. I have obtained a decree, my lord. I will be only relying on lordship will kindly takes, my lord, 2005 volume 6 SCC. Anderson, right? Yes. Page 489. This is a judgment, wherein I'll just place 2 paragraphs. 2005 volume 6 SCC, page 489. Paragraph 5, 6, 7. I'll read for your lordship. As held by this court in Atmanam Properties, once a decree for eviction has been passed, in the event of execution of a decree for eviction being stayed, the appellants can be put on such reasonable terms as would be, in the opinion of the appellate court, reasonably compensate the decree holder for loss occasioned by delay in execution of the decree by the grant of stay in the event of the appeal being dismissed. It has also been held that with effect from the date of decree of eviction, the tenant is liable to pay mean profits or compensation for use and occupation of the premises at the same rate at which the landlord would have been able to let out the premises on being vacated by the tenant. While determining the quantum of the amounts receivable by the landlord is not bound by the contractual rate of rent, which was prevalent prior to the date of decree. The learned counsel for the appellant submitted that appellants cannot be held liable to pay anything more than the standard rent of the premises in spite of the decree for eviction having been passed, as the same is sub judice. The submissions needs a summary dismissal in view of the judgment of the court in Atmanam properties. Both the parties have filed affidavit and counter affidavit, placing on record material given the court an idea of the rate of rent generally prevalent in the locality where the suit property is situated. Canara Bank on the first floor of this building is paying rent at the rate of 25 per square feet other than maintenance and municipal taxes. One Roompa Ghosh entered as the tenant in the year 2002 is paying rent of 32 per square feet. Taking an overall view of the material made available by the parties, we think that the appellant should, from the date of the decree of eviction, pay mean profits compensation for use and occupation of rupees 15 per square feet, subject to final determination of the same by a competent forum. The application is disposed of in the terms of the following directions. With effect from 12th March 2004, the date of the decree passed by the High Court, the appellant shall be liable to pay or deposit for payment to the respondent landlords an amount calculated at the rupees 15 per square feet for an area of 567 square feet. The area which is according to the appellant is in their possession. The first deposit shall be made on or 30th June 2005, consisting of the amount calculated up to that date. The appellants may adjust by way of deduction the amount, if any, paid by them to the respondents for this period. With effect from 1st July 2005, the appellant shall continue to pay or deposit for payment for the respondent landlords an amount calculated at the same rate of month by 15th of every month. Respondents are permitted to move an application under Order 22 Rule 12 of the Code of Civil Procedure or to pursue such remedy as may be available to that under the law for determination and recovery of the mean profits which they would have entitled to recover from the appellants for the period between the date of institution of the suit till the date of recovery of possession in the event of appeal being dismissed. The respondent shall file an undertaking on affidavit making a statement that amount recovered by the respondent in terms of this order shall be refunded or remain available for adjustment in terms of any direction which the court may make an end. If any amount becomes liable to be refunded consistently with the decisions of the court in the appeal, the respondent shall refund the same within time appointed by the court for the purpose. So, Mala, may I ask this question to myself, Mala? Today, Mala, good, bad, indifferent, I have got a decree. Yes, Mala, if your lordship directs me, I'll file a supplementary affidavit now. Mala, I was not get an opportunity. Lordship will kindly, Mala, what has fallen from your lordship, Mala, I bow down, Mala. But last day, Mala, it was adjourned only on the ground. My learned friend has only taken, he only pointed out Mala, that this judgment is not, Mala. Yes. Yes. Lordship directs, Mala, the executing will dispose of that, my lord. Mala, today, Mala, it's on Taltola 700 square feet. Mala, it's not, the rent is not less than 30,000 per month. Mala, today, Mala, if your lordship is granting a stay, Mala, today, Mala, then Mala, the landlord will be superly, Mala, lordship will kindly take the Atmanam properties, Mala, the blooded, the honorable supreme. Yes, paragraph 18. Yes. So, Mala, I was just showing. Mala, and I am also carrying this High Court judgment, Mala, of 9. Mala, material lordship can always, Mala, takes it, Mala. Lordship can additional evidence, Mala, I can always produce in the appellate stage also, Mala. Mala, today, Mala, rate of rents, Mala, one thing, Mala, lordship can direct, Mala. Lordship can appoint and Mala, commissioner, Mala, Mala, who will go and Mala, visit and will take the, Mala, the visitors, Mala, localized, Mala, who is residing, Mala, Mala, will produce that document, Mala. But let it be decided. Well, my question is, well, very, well, I want to be in equity. If today he wants to challenge whatever the decree I have obtained in section 41 proceeding, well, he has to put in cost. Well, he will file frivolous litigations and he will not put in cost. Well, I obtained a decree in 2019. Very good, great. But I'll find. Very good, I'll find. But I'll find it. Yes, yes. Well, 10 days time I require. Well,
Great.
next year loss will kindly clarify. Well, let it be returnable on matter. I'm done.
কবে রিটার্নেবল করলো?
Returnable 2 weeks for.
Mart has it. Grateful. Much of you know.
Well, take back.
আমি বলে দিচ্ছি। But may I take back the books?
Opposition দেবে? আমাকে একটা বই আমাদের।
ওরা একটা অ্যাপ্লিক করবে। আপনার সঙ্গে বলে দিচ্ছি কি করেছেন। একটা আমার আছে। থ্যাংক ইউ। আমি বলে আসছি।
একদিন তো দেয়া আছে শুধু অ্যান্ডারসন।
কতদিন পরে আসবে? 2 weeks পরে?
I am for the appellant.
দাদা কতদিনের মধ্যে আমাদের affidavit? এটা করে রেখেছো? জিজ্ঞাসা করুন সেটা জজ সাহেবকে বলুন। বলুন। My lord, subject to my lord, we have to file the affidavit within 15 days. The matter is returnable on 15 days. My lord.
I am for the appellant. My application for restoration, my lord. My application was dismissed in order 41 stage, my lord. So, my lord, service not, I have not served any on, my lord. My lord, my application was dismissed on, my lord. Application was dismissed on, my lord, 5th December 2019, my lord. Thereafter, my lord, pandemic was started, my lord. After recovery that period, my lord, I filed this application. My lord, on and sudden, my lord, the matter was appeared, my lord, and my lord, it was dismissed for default, my lord. GA1 is my application for restoration. Yes, my lord. After just pandemic, my lord, 2022, my lord, September 2022, my lord. My lord, during that period, it was depart from, my lord, the I have played in my application also, my lord. Separate application, my lord. As you lord. Give me, my lord, 10 days time. You already fix the matter after 10 days, my lord. It was dismissed in the order 41 stage, my lord. If your lordship desire, my lord, I start, my lord. your lordship fix the matter on any day, my lord. কবে fix করলো? কবে fix করলো? হ্যাঁ,
19.
Lordship, I am appearing on behalf of the petitioner. Lordship, I beg to pardon in this matter before your lordship. Lordship, that in this matter, file a restoration applications against the order, against order 1st January 2018. But restoration application was filed on 22nd February 2018. Lordship, 13 days delay. Pray for time to file Section 5 applications.
As prayed, time is allowed for filing an
2 weeks
application
time.
for condonation in accordance with law. Bondi.
কবে থাকছে? After Lordship, pay for 2 weeks, Lordship. Pay for
2 weeks.
2 weeks. Give.
My lord, I am for the applicant defendant, my lord. My lord, this is a appeal against an order of the City Civil Court 6th bench.
Against the order?
Of City Civil Court 6th bench. Oh. Now, my lord, there was a suit for declaration, and in the declaration suit, my lord, we had challenged a gift deed by Kamala Mullik, who was at that time 80 years old and unsound in mind, paralyzed. So, in that, my lord, we were proceeding with the suit, and we now there is a the suit is pending, and eject. A title execution has been filed, my lord, whose date is on the 22nd of this month. These are the copies, my lord.
They are defective. They are being presented.
আর একটা কপি আর একটা কপি আছে ওতেই দুটো কপি আছে বোধহয় হ্যাঁ হ্যাঁ
একটাই নেক্সট ডেটটা আমাদের নামটা
This is the last order, my lord.
Your appeal is defective.
My lord.
You have not checked. It is out of time and there is also some substitution.
No, it was filed in the, 2019, my lord.
You should see the report of the department is there that it is out of time and there is a substitution also required. There are 2 defects reported.
My lord, then the substitution is to be filed.
Just check what is to be done for taking steps with reference to the defects.
And in the meantime, can there be a stay, my lord?
The
Because 22nd is the
application
date.
is adjourned to stop made returnable after 1 week. 1 week. There are 2 defects. Just see. 32 days. But they're not.
No, no. They didn't have file. File tha.
But my application for restoration of my appeal as well as the application, that it was dismissed for default on 27 September 2022, which your lordship will find at page 8. Page 8 of Can 2, which will find the order of dismissal.
So first you file the appeal after 5,500 days.
Yes.
And then you get it dismissed for default.
I can't have the facts, my lord. The appeal was filed. Thereafter, my lord, the application for condonation of delay in preferring the appeal, that was Can 1. And that was not moved, my lord, when it was called on the advocate. The previous advocate was not there. There has been a change, my lord, in the advocate on record.
There's so many defects.
Yes, my lord, I can see an order, my lord, of the department. This is the 13th May 2022, where it has been observed that there are some defects, but my lord, since there is a change in the advocate on record, unless
13th May 22.
Yes, my 13th May 2022, there's an order passed by the registrar administration. If your lordship has that order in our record, that it is recorded here that there, as per the office report, there are some defects, and the appellant's advocate was requested to take necessary steps. But my lord, the erstwhile advocate was not even there on that occasion, and my lord, unless the appeal and the can is restored, the current advocate on record cannot cure the defects.
You are appearing.
Service was Your lordship kindly allows the restoration, then my lord, I can proceed and cure the defects and then come back for condonation, my lord, whichever way your lordship decide.
When was it dismissed? September 22.
Yes, my lord, 27 September 2022, and the litigant, the appellant's knowledge was on 17th April 2023, which is pleaded in paragraph 5 of my application. Thereafter, this restoration application was filed.
Which is the application for restoration? 2.
2, yes, Can 2. Page 8 is the order of dismissal.
You served a copy.
Yes, but I have served. May I file the affidavit? Affidavit, sir. Same copy. no? But there is only one copy. I beg your lordship's pardon, my lord. We should have carried.
You have to file 2 copies.
My lord, we shall prepare, my lord.
Bring
for
it
now.
tomorrow.
Very well, my lord. My lord, grateful. my lord.
I appear for the respondent number 1.
Lord, I am for the plaintiff appellant. Now, this is my service.
Before your lordship looks into the papers and he begins his submission, my lord, I must indicate to your lordships, my lord, the suit has been dismissed for want of prosecution already. My lord, he is over here challenging an interim order which has been passed in that suit. My lord, may I just give...
Your suit is already dismissed.
My lord, may I submit to lordship, my lord? The memorandum of appeal has been filed in the year 2022. Thereafter, they have filed caveat. We have served the notice and with the petition. At the learned court below, when the adjournment injunction was not granted, then my lord, this appeal has been filed. But my lord,
Now the suit itself is not there.
but my lord, they have not communicated this, that they have already obtained the certified copy, the copy of the petition, but with also the stay petition in the learned court below. Hmm? And they also not submitted any objection. My lord, when my humble submission to my lords, that when they have the knowledge that appeal is filed at this honorable court,
You are the plaintiff.
yes, my lord.
Your suit is not there. What is to be done now in the appeal? When
My lord,
the
may I
suit
submit-
itself is not there, what is
because
to be done?
we have not affiliated with the learned court below, because my lord, we had challenged the order in
Whatever it is, unless that order is obtained by the suit, by the trial court, what can be done here?
I feel, my lord, but my submission is this: why, my lord, they also have some duties because they are the.
You are the plaintiff, sir.
I am the
You
plaintiff.
are the plaintiff. You are the appellant.
No, we came to
You
know.
know that the suit is dismissed for
We
default.
came to know, my lord, last 2-3 days
Whatever it
prior
is,
to that, my lord.
nothing remains now. As of now, nothing remains.
May I submit to lordship, my lord? Lordship, my lord, kindly remand the matter. I will make the application for restoration.
Can this be remanded? This is your appeal.
Then, my lord, kindly make it pending, man, sometime.
Hey, the suit is not there. It will give you liberty to file application if it is restored. That counsels are ad item on the issue that the suit out of which the present appeal arises has since been dismissed in default of appearance. To stop in view of this development during pendency of this appeal, there is nothing that remains to be considered in the present appeal. The appeal is accordingly dismissed. The application and appeal are therefore dismissed. The petitioner, the appellant, however, shall be at liberty to proceed in accordance with law.
আমি এই তুলে দিচ্ছি
সার্ভিস হয়েছে সার্ভিস হয়েছে
I have the defendant responding this matter, my lord.
Well, in this matter, my lord, I am appealing for the appellant petitioner. This appeal is directed against the order grant of letters of administration of an will, where the objector and this appeal, the application for stay was filed in connection with the said appeal. And this honorable court, my lord,
Yes.
page 15, your lordship, pass an identity order of stay or the injunction restraining the opposite parties from transferring alienation and encumbering the property which is the subject matter of the will.
By which order?
The order dated, my lord, 17th of February 2023. Page 15. Paperwork file হয়ে গেছে? সার্ভিসে যে paperwork? ডিপার্টমেন্টে ফাইল হয়ে গেছে তো? I am drawing a lot of attention to internal page 2 of the page 16, third paragraph.
What is the can remaining now?
Yes. Now, my lord, kindly consider the subsequent development occurred. That's why this application has been filed. What my learned friend's client has done, now he tried to mutate their name in the concerned revenue records. Though revenue record does not confer any title, it is any immovable property. If your lordship can turn to page 18 of application, my lord. Application which I filed, my lord. Joshua, application, application.
Can 2.
Can 2.
Paragraph 18.
Page 18, my lord. I'm skipping over the portion, my lord. Can you turn to page 20?
These are orders passed in which proceeding?
They filed an application for mutating their name in the concerned record of rights with the revenue authority. Pursuant to that application, my lord, the concerned authority under section 50 of the Land Reforms Act found and dismissed their application by holding, my lord, page 20 from the top, my lord, your lordship find. It is found that the applicant has obtained the suit property by instrument of transfer / partition / succession on the following description mode of transfer. Sale deed number 002 dated 5th February 2014. Claimed plots does not match with the field verification. Petitioner does not possess the plan. Document produced do not match with the claim. Not satisfied, hence rejected. Case dropped sub judice. Now, my lord, against that, my lord, they preferred an appeal. Now, my lord, can you consider?
Against this order, they went in appeal.
Appeal under section 54.
Page 21 Land Reforms Act.
Yes, under the specified act. I'm conscious about the fact, my lord, this is 2R of the. It is amenable to if I want to challenge the same. I'm not on that. My lord, can you turn to page 24? Last 2 lines. No, now from the impugned orders, my lord, got it, last paragraph, page 25. Now from the last paragraph, now from the your lordship find.
Yes. Yes.
On the strength of registered deed being number such and such, but at the time of hearing, the applicants failed to produce that registered document. The respondent side also failed to submit in order passed by the any court relying upon which the revenue officer took decision that is dropped and matter sub judice. Now from the fact, the case is dropped as the matter is sub judice. Now from the facts mentioned here, concerning the submission of both the parties order that the impugned order passed by prescribed authority is in such and such is set aside. Below Adjournment directly hear the matter afresh by issuing notice to all interested parties. And this is a matter of passing written order in 2 months from the receipt of the certificate, which direction that it is the case is dropped and matter of sub judice. My lord, this is, my lord, why, my lord, I am before your lordship, because this order is subject matter of challenge under the specified act. Now, my lord, this has been done with the intention because my lord, transfer of the sale deed. My lord, it's found that their strength is on the basis of the transfer which is effected by a sale deed.
Yes, that is not the subject matter in these proceedings.
Yes, now, my lord, this property which is the subject matter of this probate, this is the subject of mutation.
But it cannot all be brought into this
That's
case
why
arising out of the Succession Act.
That's why, my lord, in other way, my lord, I
Seek your remedies in the appropriate forum.
yes, I can challenge this order. I can ask before your lordship.
Same order is only to the extent that
That no third party interest be created.
right will not be created.
Yes. Now, my lord, what the change circumstance? What is the change circumstance? By this, my lord, I draw a lordship attention over the position, my lord, the primacy. It was held that the petitioners, the applicants, or the opposite parties herein are not in possession of the property in question.
See, the interim order, the injunction has a limited scope.
Yes, well, so for the position now, my lord, I am the basis of the position.
That cannot be introduced here.
Because of this change, otherwise, my lord, I will not. Because, my lord, the document, the entry in the record of rights
is not the issue. The issue is whether the letters of administration was granted properly or not. That is the only thing.
Yes.
There is no issue of.
So the property, my lord,
what is the remedy under this act?
Under the West Bengal Land Reforms Act.
They have to challenge before
The West Bengal Land Reforms Act, that's it comes within the purview of the.
Can you please show the provisions?
Yes,
I want to take the opportunity of examining it. Yes.
Sorry, my lord.
Yes. You proceed as if.
That can be turned to jurisdiction and authority of the tribunal.
West Bengal.
West Bengal Land
Land
Reforms
Reforms
Act.
No.
Jurisdiction and authority of
Huh?
So this morning also in one case I was repeatedly asking about the small quarters.
Section 6 below.
Yes, specified একটা কথা আছে সেটা দেখিয়ে দিই তাহলে
Land Reforms Act.
এই তো ওয়েস্ট বেঙ্গল ল্যান্ড রিফর্মস এন্ড টেনেন্সি ট্রাইব্যুনাল একটা এই যে স্পেসিফাইড একটা এফটা দেখাতে হবে না হলে হবে না you should read 6 along with F দিয়ে দেবো ওরে বাবা
Get the pair act.
it is much lighter
You'll find it.
my lord will text my lord if at the West Bengal Land Reforms and Tenancy Tribunal Act.
It's not here.
আমাকে তো বার করে দিই may I find it out for your lordship? সিভিল অ্যাক্টের মধ্যে থাকবে কি সিভিল ল্যান্ড রিফর্মস একটা আছে গো ল্যান্ড রিফর্মস একটা দাও না ল্যান্ড রিফর্মস একটা দাও পাতলা ল্যান্ড রিফর্মস একটা ওতে পাওয়া যাবে আচ্ছা আমি দিয়ে দিই
We have the Land Reforms Act.
Yes.
It is that page.
Land Reforms and Tenancy
ট্রাইব্যুনাল অ্যাক্ট ওয়েস্ট বেঙ্গল এন্ড ল্যান্ড রিফর্মস আমি দিচ্ছি তো
So there is a remedy against this.
yes I'm not challenging this order. I am before your lordship that
So the basic order which you just referred to is passed under which provision?
54 under the West Bengal Land Reforms Act. Now, my lord, if your lordship may kindly consider 2F of the West Bengal Land Reforms Tenancy Tribunal Act.
Section 54.
54 of the West Bengal
Mutation proceedings.
Yes.
Mutation proceedings. 54. No, 54 is the appeal. Section 50 is the
54 is appeal.
Appeal.
Against the order of the revenue officer.
Yes. If the order passed by the revenue officer, it will be before the
Collector.
collector.
And if by the collector before the commissioner.
Then, my lord, West Bengal Land Reforms and Tenancy Tribunal. There is no second appeal. Only the first appeal, that is before the collector, who is being the additional district magistrate of the concerned district. He can also remand the matter before the SDLRO.
If the order is passed by the collector, then appeal will lie before the commissioner.
Yes, if it is the parent order is passed by the collector.
That is what I was thinking.
Yes, my lord. Then, my lord, it is before the commissioner of the said division.
And the order in appeal is final.
Order is available. Then, my lord, we have to invoke, my lord, the provision under the West Bengal Land Reforms and Tenancy Tribunal Act.
Oh, there is a tribunal providing.
Yes, my lord.
Under which provision?
The act, section, no,
Yes, section 10.
section 10.
Page. Okay, I'll see that. No? Oh, in that one. M2 then.
Now, my lord, you will automatically turn to section 6 of the said act, of the Tenancy Tribunal Act. The jurisdiction of the tribunal, my lord, got it?
Yes.
There you will also find the specified act, any order or action by the authority under the specified act. My lord, got it? Now, my lord, please give turn to section 2, subsection F. The names of the specified act are there, my lord, if you lordship are calling it, section 2, subsection F. Subject to correction, my lord. Specified act. F to F declared na go.
If you don't have a copy, you refer to it. We'll look. Don't worry.
Yeah, that's,
You give that.
okay, okay. এই যে
R.
এই R
Section 2(8).
মানে section 2 R. আমি একটু guided মানে sorry মানে I have misquoted the section. You'll also find II.
Yes.
Well, I've got II. So the acts or the proceedings initiated under the West Bengal Land Reforms Act is subject matter of adjudication under the West Bengal Tenancy Tribunal. I am only on the basis that the respondent cites the findings which is because that will cause the problem in future. The respondent side also failed to submit any orders passed by any court of law relying upon which the revenue officer took decision, the case is dropped and matter is sub judice. These four, I am not challenging the order. The revenue officer can done anything if not upon review. I am not on that after remand.
That is if it's to your detriment in any way. This is your remedy under section 10.
If my lord, I am not
That
challenging.
in a collateral proceedings,
So,
in these proceedings, a collateral relief for a purpose which is alien to the entire issue pending in these proceedings.
so for the pendency of the proceedings, well, civil proceedings can be termed to be that case is dropped and the matter is not sub judice. We are brought to the attention that portion, my lord. My lord, can consider if that is the portion, it is not sub judice. I'm not challenging the order. The remand, what is the remand is made? It is. I have no objection. I'll find out the litigation over there, or I could have challenged the matter. Now,
Case is dropped as matter is
sub judice. No, it is the consider, my lord. Next, before that, my lord, the respondent side also failed to submit.
But the finding is that it is sub judice.
No, my lord, subject to question, my lord. Can you turn to earlier page 25?
No, page 20.
25, last line. It starts from the last, the respondent side. My lord, got it? At the bottom, page 25, last.
That finding will hardly be of any relevance in these
Yes,
proceedings. None whatsoever. And it is open for you to assail this finding.
The respondent side also failed to submit any orders passed by any court of law relying upon which the revenue officer took decision, case is dropped and matter is sub judice. When the matter is subject to the direction, and that is a fact before the revenue officer.
Representing you did not produce anything, then what can be done?
That is why so this is the finding based on my lord. This finding is causing if the authorities of the opinion there is no sub judice matter before the court, then there is no embargo on the part of the authority to proceed with the mutation. My lord knows the mutation coupled with position. If today, my lord, this findings is there, then I have to go before the authority and say that no, there is no sub judice because in view of the appellate court direction, there is no litigation is pending amongst the parties.
But now it has been referred back to the BLL and LRO.
Yes, that is why, my lord, these findings, if I had not brought to the notice of the higher authorities, my lord, then I could not have
Either you are required to go back to that forum and tell him that, yet, look, this is the order of the High Court, or you have to go in the appeal before the tribunal. Nothing can be done in these proceedings. That's all.
No, so these findings is detrimental so far because there is a finding order passed that no third party interest will be created. And this mutation is the nothing but no, this is a creation of third party. And this subject is not the subject is my lord, the findings by the appellate authority with these findings, whether it is detrimental or contrary to the direction passed by this honorable court in the pending proceedings or not.
You were the defendants in the suit, in the.
Yeah, objector, my lord, I am the objector.
Yes. The present appellant was the objector in the proceedings seeking grant of letter of administration. Stop. In the present appeal, after due consideration of their submissions and upon after due consideration of submission of the parties.
Yes.
Yes. This court, by an earlier order dated 17/2/23, directed the parties, directed as follows. You take down from page 16. Stop. The present application has been taken out in view of such an orders passed in a mutation proceedings at the instance of the plaintiffs. The learned counsel for the appellant submits that though the present application, the present appeal is pending and the matter is sub judice and an interim order has been passed in the present proceedings, the appellate authority under the West Bengal Land Reforms Act has in the appeal filed by the present appellants observed as follows. Take from page 25. Stop. We have gone through the order passed by the appellate authority in the proceedings arising out of the Land Reforms Act. Stop. We find that the appellant has remedy by way of appeal under section 10 of the name of the act. The name of the act. West Bengal Land Tribunal. Yeah. 139. The West Bengal Land Reforms and Tenancy Tribunal Act 1997, if he is aggrieved by the observations recorded in the said order, the learned counsel for the appellant has tried to impress upon the court that such a recording is contrary to the facts as apparent from the order dated 17/2/2023 passed by this court. To stop. We are and therefore he seeks a relief in the present application for staying the order passed by the appellate authority. The appellate authority is a judicial office.
Well, the is not a quasi-judicial authority. trappings of civil code, my lord, exercising power of the civil procedure code for the power of summoning the witness and cause examination.
What is the relief that you have prayed for?
Beg your pardon?
What is your relief in the application?
Yes.
That will mutate na
Not to mute it or to take steps.
stay from the.
Stay, my lord, stay, my lord, practically, my lord, so far the stay is concerned, my lord, the prayer which I made, that is not permissible before this model code. That's why I did not praise that prayer also before your lordship. Because that amounts to, my lord, interfering with the adjudication which is subject matter adjudication before the tribunal.
Yes.
I am on the basis that observation portion, but if it is not a sub judice matter, then, my lord, I am not here.
What is the relief that you want?
Be-
What is the relief that you
That portion that it is a sub judice, that portion should be deleted or that should be modified to that extent.
want? And praise that the order. Yes, take down.
And one thing, my lords, as your lordship was pleased to hear that my remedies, yes, that's my submission also. We have the tribunal, 5 days or 6 days, sir, we can prefer the before the tribunal also.
So you don't want dismissal of the application?
My lord, this with that,
All right.
right? My lord,
Yes. Yes. What did we write? He seeks a relief in the by way of the present application for deletion or modification of the observations recorded by the to appear with the said order as it is in a distinct proceedings, and we do not find the same to be in any way in conflict with the interim order, the injunction granted earlier on 17/2/2023. We therefore would dismiss the application, with liberty, however, to the appellant to seek his remedies in accordance with law under the Tribunal Act noted above.
কেন করবে? এই যে উপরটা যে লিখলো যে কারেকশনে এইগুলো ছিল এটাই সাবজুডিস হয়ে গেল।
For 24 Malar, I beg to appear for the appellant. Your junior name number? No, this relates to land acquisition proceedings. Initially, award was granted by the collector. Being aggrieved with the collector's award, they moved before they filed a Section 18 application, and that particular application was transferred to the LA judge, and LA judge has enhanced the amount with a bizarre reasons, saying that 2013 Act would be applicable. Whereas fact is, in 1976, possession was taken by the state, property was initially requisitioned, thereafter Section 4(1)A notification was issued in the year 1997, and the award could not be passed within the lifetime of the Act 2.
There is a
That's
delay-
how it
delay
got
of 403
delay
days.
of 400.
More than a year. Hey. You have served a copy.
No, I have served, but I am not.
You have
not
served, you have to
within
file
every
an
bit of
affidavit.
service. I have
File it,
I have
file,
served.
file it, file it.
Yes.
For filing affidavit of service, matter is adjourned next week.
Next week.
In the next week, to be listed after 1 week. Are there any other defects?
No, nothing.
তবু এক সেকেন্ড একটু মেমোটা দেখে বলবে আর কোনো ডিফেক্ট আছে আসেনি?
File 25, my lord, I'm for the respondent.
My lord, I'm for the applicant, my lord. This is my,
Paying for a day's accommodation, my lord.
my lord, this is my application for extension of interim order, which has been passed by this honorable court. It was passed on 27th February, which has been extended again on 13th May, lordship. We have filed within time, lordship.
13 May till which date?
27th of
It was till for a period of 2 weeks, and my application within time. Kindly fix a date for hearing, lordship, of the main application, and in the meantime, my interim order may be extended.
There have been certain changes in the interregnum, my lord.
We'll consider on the next day. But where is the last order?
Last order, page 9 of my application, lordship. This is the can 4. Page 9 is 13th May 2024.
My lord, I will oppose this extension because, my lord, in the interregnum, my lord, I have filed the suit before in this honorable court, and I have gotten an injunction, and I'm carrying the order of injunction, my lord. I'm sorry, it's not. It's stapled.
Without serving me, I don't know how he has filed injunction. When my appeal was pending, he has appeared here. Suppressing this fair, he has taken injunction. We'll take care of that.
There has been absolutely.
Let it be heard, lordship. Let it be heard on the date fix.
Their suit before the City Civil Court was filed in December 2023. Their ad interim injunction was rejected in 2023. Until date, they have not even served the summons.
No, they have. He's making a wrong submission, lordship. They have appeared. They have filed. Time to file written statement. I'm very sorry. How could they make this submission? I'm very sorry. Lordship, may kindly fix the date for hearing of the application, lordship. And
I have been granted an injunction by this honorable court, my lord.
What is the date on which the interim order was granted?
that is
24th June.
the first order was passed on 27th February. That was annexure P1, page 7 of my application. Status quo. This was subsequently extended on 13th May. Page 9. File के
13th May.
Lordship. For 2 weeks. And my application is filed on 24th May. Within time, Lordship. We have served the copy of them then also. Lordship, we kindly fix a date for hearing.
Do you file your opposition?
My lord, we will, my lord. only one thing, there has been no suppression when we've obtained that
So
injunction.
when you file your opposition, we'll consider everything. Let the status quo as it is, continue for a week, you come back in the next week.
Without affecting the injunction that I have obtained.
That is not before us today, we'll not take notice of that, yes. The application today is for extension of the interim order, which has been passed and extended by earlier orders. Dated 27/2/2024 and 13/5/2024 respectively. And counsel for the respondent submits that he shall be filing an affidavit in opposition to bring on record certain events, comma, in the meantime, in the interregnum, full stop. How much time?
Very limited.
How much?
1 week.
He seeks 1 week time for filing the affidavit in opposition. We allow the prayer for, we allow the time sought for filing an affidavit in opposition. Matter is made returnable after 2 weeks, full stop. In the meantime, in the meantime, if so required, the appellant may place his affidavit in reply. The interim order is extended to till the next date or until further orders.
Grateful, Lordship. The date could be fixed, my lord, after 2 weeks.
We have said returnable after 2 weeks, it will come. Acha, according to year, chronologically.
Yes, eh? With regard to item 26, next one, I am praying a 1 week time because my senior was here so long. But he has a matter fixed in the court number 29.
All right. As prayed by
of the respondent.
as
but
prayed
the
by the
complete-
appellant. Yes.
Complete copy of the plaint has not been served upon us. Complete copy of the plaint which has been annexed to the appeal.
You give him a, why are you?
Complete copy has not
That
been
will only frustrate.
kindly have
I will take it and serve it.
That will frustrate the hearing of your application.
I will serve it.
As prayed, that is adjourned for 1 week.
Complete copy দেওয়া নেই
না
প্লেন তো আপনারই প্লেন
আমারই প্লেট you have annexed you have annexed to
His plate, my lord. আপনারই তো প্লেট নিয়ে যান
Yes, you are appeal. In 27 also, same prayer.
27, I appeared for the respondent mallet, respondent husband mallet.
This is a appeal regarding the matrimonial suit.
This is 26.
I am for the wife, my lord, the defendant.
Oh, which matter has been called? 26.
26 is over. The lordship has typed for time.
Yes.
This is 27, I think. 27 দেখেছেন কি? 26 এর টাইম হলো। One week time হয়েছে।
Twenty-seven.
27, my lord, I am for the appellant wife, my lord.
For the husband respondent mallet.
He was a respondent in the matrimonial suit.
It has been decreed.
Decreed
Now, my lord, the short question is what I find from the decree itself, judgment that whether the decree can be passed solely on the ground of the deposition of the wife. That is the defendant. The case of the
What are
plaintiff,
the grounds?
case of the plaintiff is that
Has been allowed on which ground?
allowed on the ground of my allegations, not on the allegations of the husband. Under section 23(1)(a) of the Hindu Marriage Act, I took the defense that he cannot take the advantage of his own wrong. The Lordship will kindly find from the judgment itself. Each and every issue.
It has been allowed on the ground of desertion.
No.
Desertion and cruelty, madam. Madam, 2002.
Desertion was not the issue at all.
2012 marriage, madam. 2016
No,
the wife went away.
All right, just wanted to know the grounds.
But I have filed an application for cancellation of bail. Passport was, according to order of the division bench, passport was submitted to the investigating officer by the husband, and that was the ground of cruelty. I have made an application under section 24 of the CPC for transfer of the case from Barasat to Malda. That was the ground of cruelty. That was what London Court has found. Kindly see the summary of the judgment is summed up by the London Court below. Running page 18 of the judgment. The court has summed up. Compelled him to deposit the passport to Raiganj PS. It is under the order of the Honorable High Court. Compelled the husband to attend the court of Malda on every date of hearing. This is the order of this court.
In camera. Sub application,
My lord.
same order, 1 week, returnable 1 week.
My lord. Date, returnable date.
What is the?
Arma 30.
Pursuant to your lordship's earlier direction, I have attempted to serve upon the respondents as well as the learned advocate representing them before the court below. The service, the person we tried to serve, the parties, it returned unserved, but the learned advocate received the service. Today is the returnable date, my lord, they should appear. My lord, this is the article which my lord, returned as answer. What happened in the suit also, we tried to serve, return answer, we caused substituted service. So the address is fictitious. The address is not their proper address. That is why, but the learned, my affidavit of service we kept. But the learned advocate representing them, my lord, they have received the service. Right? They have received the service. This being the position, if my lord so directs,
Yes.
fixing a day for that when I can serve upon the, because computer ache. In the last order, my lord, interim order was granted, but there was no time mentioned. So I thought it's my duty to place the matter before your lordship at the earliest. দেখো তো আমার 2 মিনিট হবে না তো আদার সাইড নিয়ে থাকতে হবে
You are the defendant.
I am the plaintiff appellant here. I must be candid because that resolution, copy of the resolution referred at in the first order, but that I could not bring, my lord. But that is my idea because I thought that person, the other side would appear and they might file an opposition to this. Because that filing of that resolution, that might end the entire proceeding. So, my lord, if they appear, and today I am also handicapped because, my lord, I have some personal difficulty also. One of my nearest one is in hospital. Anyway, my lord, be that as it may, my lord, other side's presence, my lord, if my lord so directs, fixing a date, maybe in the next week, any day, so that I can serve again upon the learned advocate appearing for them. I have already served upon them. Private respondents, it should not be private respondents, it should be respondents. Mr. Obhinobo Da, my lord, that particular day, he appeared, my lord, virtually. So we could not collect his, my lord, phone number or, my lord, his contact number. But I do not know whether they have already filed any Vogaladnama or not. I do not think so. Because that particular person, he appeared himself for the respondents, but his Vogaladnama must be there. But the lower court advocates duly received the copy. Not the copy, the intimation. I stand corrected. My affidavit of service is my lord. Order copy.
There is no material to show that you were elected.
Well, that is why this honorable court, my lord, granted me liberty to produce the minutes book. But one of the minute book I have produced that immediately after his, my lord, removal, that is in 96, 97 resolution is with me. That is, I am the general secretary. I have been elected after the removal of Mr. Probir Ghosh. But recently, at the time of filing of the institution of the suit, that copy of the minutes book is I am handicapped, my lord. I'll be beseeching any day in the next week. That is my difficulty. I stand, my lord.
Yes, as prayed by learned counsel for the appellant. Matter is adjourned 1 week. Give him back the affidavit of service. You file it on the next date.
Absolutely, my lord.
File the affidavit of service on the next.
I'm deeply obliged, my
In
lord.
the meantime, you can just, if you can catch hold of the learned counsel, you let him.
My lord, would your lordship is kind enough to grant to add one line to serve upon the learned advocate?
But you said you have already served.
I have already served. They have already received, along with the copy of the order.
The learned counsel for the appellant
date
is
is on
also
15th.
granted liberty to effect fresh service upon the respondent as well as learned advocate representing them and file affidavit of service in this regard. List after 2 weeks, 1 week, 2 weeks.
But not the respondent, because the respondent's advice has returned as answered, because that will not give any effect.
Take fresh steps.
Again, my lord, I'll try.
Yes.
Definitely. Vice. I'll just follow.
What do you want?
But items numbers 31 and 32, my lord, are connected matters. My lord,
Items?
31 and 32. My lord, Mr. Jishnu Chaudhary was leading me in the matter. My lord, he's on his legs. I humbly beseech your lordship to kindly take up the matter tomorrow, my lord.
He's in some difficulty.
The last person to oppose, but can you take it up next week if it's possible?
Very well,
Because
my lord.
it's difficult, my lord, to tomorrow, my lord. I don't know whether your lordship would take up, my lord, only order 41s or it will take go on, because after 2, my lord, what happens is usually the appeals are not fixed. And there, my lord, it might be then I'll have to come and pray, my lord. Any day your lordship pleases, I have no problem, sir.
Next week.
Lordship, any day.
Respond number?
21.
But I say whether I have no problem in fixing the matter next week, but maybe after 17.
After 17.
Holiday.
Huh?
Possibly a holiday.
Mohoram.
Maybe 18, 19.
What is the issue?
My lord,
I didn't tell you.
your lordship recalls this is that matter where your lordship, my lord, we had handed up copies of deeds. My lord, there was disparity. So your lordship had called for a report, my lord, from the registrar at Asansol.
Yes.
But there is some urgency, my lord. They are, my lord, constructing. Any day this week, if your lordship permits, any
Week
day.
may not be possible.
Yep, I leave it to your lordship.
Also, but I because at least me whether
We'll fix it on 19th.
Very well.
As jointly prayed by parties, matter is adjourned. to be taken up on 19/7. So grateful. Grateful.
Lordship, I'm for the appellant.
Yes.
Today or not today, my counsel. Your Lordship would remember this matter, Your Lordship. I placed a proposition that injunction cannot be granted in case of application for grant of letters of administration in absence of a separate application for administrative pendency light. Your Lordship has heard this matter and has kept the matter under the heading fixed matters for passing of necessary orders, Your Lordship.
This bench has not heard you. This bench has not
Yes,
heard.
Your Lordship could keep it for hearing, Your Lordship.
We'll fix this. The matter appear as that is nothing. They will just ask for issuance of.
Great. Great, Your Lordship.
আমি দাদার ট্যাবলেট সাইড ট্যাবলেট সাইড কিছু সাবমিশন তুমি
$34.
34 is
$34. The applicant, my lord. The applicant, the applicant who is related to the yes, my lord. The in relation to the can application number 3.
Submission. Can I see it? No, can see the Catherine application.
1 second. We have served already.
No, just click the can application. I want to see which 48. Addition of apartment.
The wife, the newly married wife.
Write your senior's name, your name. Addition.
The probability is he's supposed to come. Thirdly, particular on section can 3. And for section 5, direction for affidavits. Only can 3 has been made returnable. Getting their application.
Additional
First to prefer second wife. The newly married wife. Yes. Consider the judgments have been placed. Much of this. Monday, they are not still the judgment very order. It will come at the top of the list. We'll pass the orders. That is all that is required. Memo of appeal টা দিন, অর্ডারটা লাগবে। Memo of appeal টা দাও। অর্ডারটা
Number 35, Willard, my appeal, along with an application for stay. Willard, Lordship, on the other bench, when Lordship was sitting with Justice Tandon, as Lordship was pleased to hear this matter substantially, but the order was not pronounced. Anyway, Willard, I am before your Lordship, we have to do it again. Willard, suit for partition, declaration, and injunction, filed in the year 2006. An interim order in the suit was passed, Millard, on Millard 28th of June 2006. That interim order, Millard, was confirmed by a final order, which is 31st of January 2014. Millard, the parties were directed to maintain status quo in respect of the suit property, and the suit was fixed for framing of issues. In the meantime, Millard, two separate appeals were filed, which are FMAT 517 of 2014 and FMAT 5118 of 2014. There was no stay in the order from those interim order confirming the order of injunction. And order 7 status quo as regards nature, character of the property, suit properties. Millard, these are, Millard, family companies, Millard. Millard, the father of Millard, the plaintiff and the defendants, Millard. Plaintiff is the second son. Came way, Millard, from Millard, Rajasthan, set up the business partnership, which held various properties, and the plaintiff's, Millard, naturally, as the heir, Millard, has different shares. Now, Millard, it's a family company. Now, Millard, order 7, rule 11 was filed by the defendant number 1
I may just indicate.
Well,
The dispute is whether the dispute should go before the NCLT or the suit court. I appear for the defendants number 6 to 11, 29 and 30. We are also on the same board. We also say that it should be heard by the suit court and matter doesn't go before the NCLT. The short point of law that is involved is whether lifting up of the corporate wheel should be allowed and should it be
Whether?
lifting of the corporate wheel should be allowed. And after lifting up of the corporate wheel, the suit court is the court which has the jurisdiction. This is the short point. And I don't think as far as these respondents are concerned, we do not have any quarrel on this issue. We also believe that it has to go before the suit court.
kindly, my lord, takes, my lord, one thing. I'm grateful to my learned friend. An order
By consent of parties, neither a jurisdiction can be
Absolutely.
conferred, neither a jurisdiction
I
can
have
be
to
taken
argue
away.
and my lord
So we have
satisfy
to
your
be
lordship.
satisfied that.
Absolutely.
Yes.
My lord, there was a order 7 rule 11 filed by the defendant number 19, Kamala T. My lord, which is at, my lord, that order 7 rule 11, one of the point, my lord, was taken, suit is hit by section of the Companies Act, hit by the provisions of the Companies Act, that's section 430 of the Companies Act 2013. That application was dismissed by an order dated 15 July 2017.
That is the subject of the appeal.
No, there is one more application by another respondent in the suit on the same cause of action under section 430 of Companies Act. Millard, also now, Millard, despite Millard, there is a finding that the civil court has jurisdiction. Millard, in the second Millard order 7 rule 11, that Millard order 7 rule 11 has been allowed and the plaintiff has been directed to be returned. Millard, same person. Millard, common joint written statement, Millard, affirmed by Millard, the brother, in respect of defendant number 19 and 25.
So where is the first order? Is it on
Yes.
record?
First order is before your lordship. Kindly have a look at 574 of your lordship brief. 574. May I just place it for your lordship convenience? Huh? Yeah. Oh, brief. Millard, 575, the order starts. The finding, Millard, continues, Millard, till 500.
Give us a moment.
Kindly have a look at
15/7/2017.
Correct. That's 575. Lordship will straight away now come to 580. $580. That's the internal page 6 of the order. Admittedly, the suit is for partition and declaration. The accounts filed by the plaintiff and the defendant numbers 1 to 8. It is a case that the plaintiff and the defendant numbers 1 to 18 are the descendants of Sukhdev Prasad Agarwala. According to the plaintiff's case, Sukhdev Prasad Agarwala came to Calcutta in the year 1950 and started a business. In or about in the year 1954, under the name and style of SP Agarwala and Company, he entered into partnership with Mahabir Prasad in the year 1968. Subsequently, defendant numbers 6 were inducted as the partners. Now, Lordship kindly Millard takes 581. This is the background. Or Millard, I Millard place the entirety so that Millard, I don't have to place the papers. They are subsequently plaintiff number 1 and the defendant number 6 were inducted as the partner. That's 580. Thereafter, during the lifetime of SP, the defendant companies being 19 to 35 have been set up and acquired by the funds of the joint family and were owned and controlled and managed by SP, that's the father SP family, wherein the family members of SP were inducted as a director and shareholder. It is stated that the company, Kamala T Company defendant, had been acquired and managed by SP. It is further stated that shareholding and various companies owned and controlled by SP families are interlocked to ensure at least incidents of tax, business share, assets, properties of the family companies, defendant numbers 19 to 37, except defendant numbers 29 to 30 are joint family properties of SP. I have carefully perused the order of injunction passed by this court on 31/1/2014. It appears that the said order, defendant numbers 19 to 37 contested said application of filing written objection and contend that the civil court has no jurisdiction to adjudicate the grievances of the plaintiff and the suit has to proceed under the Companies Act 1956. It was further stated that the defendant numbers 19 to 37 that the plaintiff filed the instant suit for partition incorporating defendant numbers 19 to 37 except defendant numbers 29 and 30, but these defendants are not family components, cannot be enjoyed in a suit for partition. It transfers from the record that after lengthy and contested hearing, the court was pleased to pass an order of injunction with the observation. After assessing the materials on record, I find that there are some individual as well as the companies are parties to the instant suit. As per the contention of the defendant, since the companies are involved in the instant suit, civil court has no jurisdiction. But from the materials on record, I find that the present suit relates to determination of the rights of the natural and legal heirs of Sukhdev Prasad Agarwala in the assets and properties of their family. It is also material on record that some companies have been found by the family members of the directors of the company. In the instance suit, the plaintiffs filed only to determine the individual shares in the right of possession, and accordingly the suit is filed for partition, which includes the assets covered by the various companies found by the family members of Sukhdev Prasad Agarwala. It was held by this court that this court has jurisdiction to try this suit with the observation. The suit is for partition and the parties to the suits have respective share in the property, and it's the principle of co-sharership and that unless and until the shares are specifically ascertained by the court, every party has a right to the share in each property in respect, and none of them has a right to disturb the peaceful possession of the adverse. In this context, my humble view, as the plaintiff has filed the instant suit for partition and accounts of the share on the parties should be ascertained by this court, it was further observed. But it is evident that the property initially owned by Sukhdev Prasad Agarwala and thereafter such companies found by the family members, there is no evidence that joint family has been partitioned by metes and bounds and the shareholders obtain their share by the order of court or by deed of conveyance. So there is no doubt that the property in question are still a joint property. Therefore, it is crystal clear that the issues whether the court has jurisdiction to try this suit and maintainability of suit as the private individuals and companies are intertwined in a suit for partition has already been adjudicated by this court on contest on 31/1/2014. I find there's nothing on record that the said order has been set aside by a higher forum. That being the position, I am not in a position to decide the issue merely on the ground the defendant has filed a petition on Order 7, Rule 11. Moreover, going through the plaint, it is entirely, I find nothing to hold the suit is barred by law or there is no cause of action against the defendant number 19. Accordingly, I am of the opinion that this court has jurisdiction to try the suit. Thus, having considered the facts and circumstances, I am not inclined to allow Order 7, Rule 11. The petition is devoid of merit and dismissed. So this is the first one. Now, my lord, kindly have a look at.
You are in this suit, you are?
I am the plaintiff. Now, my lord, kindly have a look at.
But
the order impugned at
earlier
page.
order is 31/114.
This initial injunction order.
Yes.
This is, my lord, on Order 7, Rule 11.
Oh, but the court is relying upon that order.
That order. Now, my lord, kindly have a look at that order.
460.
At 462 of your lordship's brief.
462.
462 of your lordship's brief. Lord, lordship will find 31/1/2014. Lordship will find it's a very longish order.
Can you take us to the relevant portion?
Yes, I'll only take that, Miller. I'll not waste lordship's time.
No, this is not, we have.
468.
Just to cut things short, if we can find.
I naturally, Millard. I know my lord. 468, Millard. Kindly have, Millard, the second last paragraph.
Yes, after assessing.
After assessing the aforementioned consideration, I find that the plaintiffs as well as the defendants are facing lack of security in the respective possession. This is a suit for partition and the parties to the suit have the respective share in the property, and it is the principle of co-shareship that unless and until the shares are specifically ascertained by the court, every party has a right and share in each property in all respect, and none of them has a right to disturb the peaceful possession of the shares. In this context, my humble view, as the plaintiff filed the instant suit for partition accounts, share of the joint family should be ascertained by the court. The instant interlocutory petition related not only to the interlocutory matter and disposing of the petition, this court cannot dispose of dispute finally. Accordingly, without taking evidence, the share of the parties cannot be ascertained finally, and this suit is disposing of the interlocutory petition. So without evidence, it cannot be ascertained. But it is evident that the property initially owned by Sukhdev Prasad Agarwala and thereafter some companies found by the joint family, and there is no evidence that the joint family has been partitioned meets and bounds, and the shareholders have obtained their shares by order of the court or by the deed of conveyance. So there is no doubt that the property in question are still a joint property. So it's a finding of fact. It has to be set aside at least in the interlocutory stage, below by a higher forum. Since the plaintiff and the defendant numbers 1 to 18 are the members of the family and some of them also directors of the company, my considered view that the arguments advanced by the defendant, except the defendant number 6, does not substantiate. In disposing of the petition for temporary injunction is only considered on the basis of the affidavits and the materials on record. In the instant suit considering materials, I find the plaintiff has prima facie case in the instant suit, and if the injunction is not granted, plaintiff will suffer irreparable loss, injury and damage will cause the plaintiff. Hence, I find balance of convenience and inconvenience in favor of the plaintiffs. After assessing all the materials on record and discussions made in the paragraphs, in the foregoing paragraphs, my humble view is this, that the court already granted an ad interim injunction on 28/6/2016 and the petition is pending for a long time and there is no order to set aside the order from the upper forum, and the materials on record produce my humble view that there is sufficient grounds to confirm the order of injunction. Hence, the petition was confirmed and the status quo was passed in respect of the suit properties.
This order was passed in presence of defendant number 19.
Yes. Defendant, all contested. Defendant number 19, including defendant number 24, filed joint written statement signed by one single person. Now, Millard in a order 7 rule 11 stage, Millard, 19 files separately, order 7 rule 11 dismissed, and the other Millard company files another application, Millard, on the more or less similar grounds that has been allowed.
Page 39.
Kindly, Millard, takes Millard, page 39. Ki bolchish? Now, Millard, kindly takes the impugned order once, Millard. It's Millard, page 630. The order starts. It's by defendant number 25. Written statement, common written statement of page. Kindly page 631. Most importantly, before showing the order, kindly have a look at 484 Lordship kindly look at the malafide. Kindly have a look at page 484. I'm very sorry, Millard. I am taking Lordship back and forward.
484.
484. Kindly have a look at it. Written statement on behalf of the defendant numbers 1 to 5, 12 to 16.
484
of your Lordship's brief. Written statement. 484. Which is affirmed.
Yes.
Which is filed jointly and compositely by defendant numbers 1 to 5, 12 to 16, 19 to 28, 35, 31 to 35 and 37. So 19's application of 19 under order 7 rule 11 dismissed. Millard, they have filed written statement together, affirmed by the same person. 25 now files. His Millard on the same ground has been allowed. Millard, it has been affirmed by same person.
This written statement was filed after filing a petition?
No, before. Long before. This is 2007. Sajjan Kumar Agarwal, the defendant number 2, Millard, files it, Millard, on behalf of all these defendants. Defendant number 1, and this is, Millard, affirmed on in the year 2007, which Lordship will find at 484 top.
29th May 2007.
29th of May 2007.
Yes.
That's page 484 top. So they file it together.
19 hour application goes before injunction. 397.
Now kindly take the application which is allowed is by 25. defendant number 25, 19 and 25
19 to 28 were all, it was
all
on behalf
together
of them.
found by defendant number 1, who is the main person.
And now the impugned order is
At
on,
page
on an application at the
631.
at the instance of defendant number
25.
Page?
Page 631.
At page 585.
দেখাচ্ছি ওটা পরে দেখাও এখনো ও অ্যাকাউন্ট করেন Now Millard kindly takes Millard page 14 or Millard internal page 14 running page 644. Or Millard kindly Millard takes from 643 onwards. The present application by the defendant, that's Millard the bottom of 643. The present application by the defendant number 25 has been filed to delay the suit, which is a subsidiary of the defendant number 19. The wakalatnama of the defendant numbers 19 and 25 have been filed under the suit by Sajjan Kumar Agarwala. I showed the written statement, that's Millard 644 top, same wakalatnama, and the same written statement has been filed on behalf of defendant numbers 19 and 25 in the suit. The said Sajjan Kumar Agarwala has affirmed the written statement on behalf of defendant number 19 and 25. Defendant number 19 has already filed an application, the Order 7, Rule 11 of the Civil Procedural Code, which was rejected on contest on 15/7/2017. And the defendant number 25, being a party to the suit, is aware of the such order rejection till date. The orders dated 31/7/2014 and 15/7/2017 are binding on the defendant numbers 5, and the question of the present application clearly falls within the ambit of res judicata. It should be 25. Therefore, the prayed for rejection of the application. Now, Millard, kindly have a look at (645), having regard to the facts enumerated in the application and the written objection thereto, and taking into note of the rival submission of both the counsel for the parties and also on meticulous scrutiny of the record, I find that the present suit has been filed by the plaintiff praying for a decree of partition in respect of the joint property business of the assets of defendant numbers 9 to 17, 19 to 37. During the pendency of the suit, there was an order of injunction directing the parties to maintain status quo over the properties mentioned in the schedule of the plaint. The defendant number 19 filed an application under Order 7, Rule 11, praying for rejection of the plaint, which was rejected on contest by this court, and no appeal was preferred against the said order before the higher forum. After rejection of the application, defendant number 25 came up with the present application, Order 7, Rule 11 of the Civil Procedural Code, praying for rejection of the plaint on different grounds, on the grounds mentioned by the defendant filed by the defendant 19 earlier. The one point which has been raised by the defendant number 25 is a subsidiary company defendant number 19, that in fact no documents have been filed on this to prove that the fact. Hence, the proposition raised by defendant under the written objection is not acceptable. The learned counsel of the plaintiff pointed out the present application falls within the ambit of constructive res judicata, as because the earlier application of the same nature has been filed by defendant number 19 was rejected. In this context, it is pertinent to mention that all shareholder director defendant company have got separate identity, and the defendant number 25 has not got its corporate identity, is not anyway subsidiary. The expression cause of action has not been defined either in the Code of Civil Procedure elsewhere, and more easily understood precisely while exercising a plaint or a petition of cause of action. The court has the full and comprehensive view of the pleadings. The averments made in the plaint and the petition could not be read out of context or isolation. This must be totally for a true and proper understanding of the case as reiterated. Now, Millard kindly takes the next page. For the purpose of determining the Honorable Apex Court in the case of Om Prakash Srivastava Union of India made an explanation on the above word. Now, Millard, kindly, these are, Millard, the observation on the judgments. Kindly, Millard, straight away come, Millard, to the finding of the learned single judge. These are this page 650. I have carefully gone through all the decisions from the side of the plaintiffs. In 2008-12 SCC, the Honorable Apex Court held that the applicable provision has to be shown that the suit is barred under law. In this case, the plaintiff brought a suit for declaration and partition involved rights of different companies, which in my view ought to be ventilated before NCLT under the Companies Act 2013. Now, Millard, my suit is 2000 Millard 6. Companies Act 20 Millard 13 Millard. this section 430 came into operation in 2016. My lord, all acts are, my lord, prospective in operation unless, my lord, lordships makes them unless the legislature or, my lord, the Supreme Court under Article 148 makes it, my lord, retrospective. My suit is a prior suit. How the express bar, if any, that is also not there clarified by the Supreme Court, of a subsequent act can make my suit, my lord, as, my lord, not maintainable before the civil. My suit is a 2006 suit.
So the other order was passed prior to this.
Other order was passed in 20. My suit is a continuous suit. It's a suit of 2006. Like Debts Recovery Tribunal has section 19, all pending proceedings transferred. But, my lord, this Companies Act, when the suit is, my lord, prior, unless that particular provision is like the Walk-offs Act. This, my lord, how, my lord, it's a case, my lord, for, my lord, transfer. There is no provision for transfer of a pending suit before NCLT. Lordship knows, my lord, in the case Supreme Court in Aruna Oswal has said that first you have to get your declaration in the shares before a civil court. With that declaration, you go to NCLT and file the application under section, my lord, on the relevant provision 59 of the Companies Act for the purpose of transmission of shares. Unless I get that declaration of how do I go to NCLT? I don't even have, my lord, the qualification of shareholding.
Let's see the two provisions.
Yes. Companies Act. Huh? No. Kindly, my lord, have a look at the Companies Act.
It may not be very helpful today.
Very well, tomorrow. I'll
hardly have 2 minutes.
Very well, tomorrow.
Continue.
Or day after, when suits your lordship, I'll come back and ask. Friday. Some precedence lordship gives because the joint family, my lord, I'll be dispossessed. These are, my lord, the persons are, my lord, the plaintiff is a cancer patient, 80 years old. My lord, impugned order 21. It was heard, my lord, substantially thereafter the change lordship knows the, my lord, marking lordship can see it lordship.
Chip, just one indulgence. Chip, we would like to take our stand on affidavit. Kindly allow us an opportunity.
Kindly do not do it here.
I did not object because my learned friend, I didn't want him to not address your lordship. Lordship can hear it. Lordship,
Yes.
only as far as the point of jurisdiction is concerned, we want
That's
to
a
find
point
out
of law. No, nothing is decided. Whether, my lord, if the person is filing, if a group of person or company is filing written statement jointly, can, my lord, file, my lord, take, my lord, two separate, my lord, application. One is dismissed. Can he maintain the other application? That is the other point.
So it's purely a question of law. We just have one, on fact, we have a bit of a tussle between us. I just want to put it on record, nothing else. On the jurisdiction, I think.
Not necessary.
Lordship can record that this is my stand. Lordship will record it if my learned friend says it. I only want to clarify on fact we have some issues which I want to clarify. On the point of law, we have nothing. Lordship, I'll file it by tomorrow.
Keeps it on Friday, my lord. Friday we'll hear out.
As per submission of, you are for which?
I am for the respondents number 6 to 11, 29 and 30.
6 to 11, 29 and 30. And what about the other respondents? They are represented?
Yes, they are well represented fully.
This is one family. They're all brothers. My learned friend is appearing for one brother. I appeared for the other brother.
Well, I am the plaintiff. I was enjoying the order. I don't know about him. My case is that, well, status quo, since it has continued from 2006, should be continued in the form as it is.
Counsel for respondent number so and so submits that he would be placing on record an affidavit in opposition to Can 1. Stop. Let him do so.
It was fine after the vacating of the order. The lift
Within-
facility stopped.
by
Everyone has to come.
Thursday. You file it by Thursday.
Lordship, I'll file it by tomorrow.
You do it, all the more better. Should I record tomorrow's date? By 9/7/2024, full stop. Matter to appear on 12th, stop. Time in the meanwhile may be utilized for filing reply if so required.
Well, I'll not file anything.
I am giving you we are giving you.
I'll not necessarily, it's on the papers. Either I win in 430 of the Companies Act or I don't. If Lordship gives some precedence, and cancel patient. So lift facility and everything has been stopped. So little precedence in Friday, Millard.
Facility and common facilities.
And the common facilities have been curtailed by the contesting
I took the
defendants. Some precedence in Friday, Millard. If it commences, I know Lordship has a heavy list, Millard. If Lordship says, I normally don't. I had mentioned Lordship says to wait. If Millard, some precedence in Friday, Millard, I leave it. Very well. Well, Lordship has permitted me.